Good afternoon, everyone. My name is Michelle Banke, and I'm one of the co-chairs of today's listening session. I am joined in this work by none other than John Skilton, a past president of the State Bar of Wisconsin. Today's listening session is the fourth such listening session envisioned by the ABA Task Force for American Democracy. Earlier listening sessions were held in Georgia, Michigan, and Pennsylvania. Before we start today's program, a few housekeeping details. In the packets that you picked up, there's an evaluation form for today's program, and we hope that you'll take the time to fill that out so that we can learn what's of interest and what else we should be talking about and listening to. There's also a sign-up sheet. This is the beginning of the work, and we are looking for how and where people want to be engaged in the democratic process, everything from speakers bureaus to signing up to be poll workers. So please take a moment and complete that form as well. As we go through the program today, you're encouraged to pose questions. At the end of the table, there are some 3x5 cards and pens. Please write out your questions, and then we'll get those funneled to the appropriate speakers. I should note that we have a little scheduling conflict, and so we had to flip a little bit of our program. The last two presentations, the election mechanics presentation, will move to 2:30 to 3:30, and then the media and civic discourse will be presented 3:30 to 4:30. I also want to take a moment and acknowledge the law firms that have sponsored the program today. Boardman Clark, Godfrey Kahn, Habish, Pines Bach, Stafford Rosenbaum, and Von Briesen. We also have a contribution on behalf of anonymous retired lawyers. If you would join me in thanking our sponsors for their support of today's program. I would also like to thank the members of the host committee. As we started, we brought together a group of people to help us determine what it is we should be thinking about and talking about and listening to. Members of our host committee include Dean Dan Takaji from the University of Wisconsin Law School, Joseph Dietrich from Husch Blackwell, Professor Chad Oldfather from Marquette University, Professor Callie Murray, also from Marquette University, Professor Rob Yablon from the University of Wisconsin Law School, Professor Bree Gross-Wildy, Executive Director of the State Democracy Research Institute and a professor at the University of Wisconsin Law School, Professor Miriam Seifert, Co-Director of the State Democracy Research Institute and also a professor at the University of Wisconsin Law School, and Professor Alex Tock, Director of the Tommy G. Thompson Center for Public Leadership. Please join me in thanking our host committee for their work in putting together today's program. I also want to take a moment and extend a special thanks to the staff of the State Bar. When I reached out to the executive director, Larry Martin, and I said, the ABA is doing these listening sessions all around the country, and Wisconsin is on the list. Can you help? He said, give me a minute, and it literally was a minute, and he came back and he said, absolutely. And not only did the State Bar agree to host this event in this space, but we've also had the help and assistance of Lisa Royce and Megan Meyer to help us pull together this program. And when I say help, I mean they did everything. So thank you very much to Lisa and Megan. And now it is my honor to introduce ABA President Mary Smith. President Smith is the first Native American woman to lead the American Bar Association. Prior to her term as ABA president, Mary was the CEO of the Indian Health Services, a $6 billion national healthcare system that serves over 2 million persons, where she oversaw the development of the operational framework that utilizes data analytics to improve services, allocate resources, and develop workforce. President Smith is also vice chair of the Vang Group. Earlier in her career, she served as an attorney at Skadden Arps, as a senior in-house counsel at Tyco International, and in the U.S. government, both as associate counsel to the president in the White House and as a trial attorney at the U.S. Department of Justice. Ms. Smith is a past national secretary of the ABA and a former president of the National Native American Bar Association. She is also the founder and president of the Caroline and Ora Smith Foundation, an organization that promotes Native American girls in STEM. Ms. Smith has received numerous awards and recognition, including being named the 2023 Business Leader of Color by Chicago United and the 2023 Director to Watch, as well as the 2023 Cherokee Nation Statesmanship Award. I give you ABA President Mary Smith.
Well, hello, everyone. I am so thrilled to be here to introduce this very special event. Thanks so much to the entire Wisconsin Host Committee and co-chairs Michelle Banke, who's going to President-elect nominee of the ABA. She will soon be President-elect. We're so thrilled. And John Skilton. And thanks so much to the State Bar of Wisconsin. We are so grateful to all of you for hosting us today and for all the planning for what I know will be an important and impactful program. And I also want to thank Elizabeth Yang for all her work in planning this event. So thanks to all of them. Well, as Michelle mentioned, this is the fourth listening tour that the ABA Task Force for American Democracy has been involved with. We were, as Michelle mentioned, we were previously in Georgia, Michigan, and Pennsylvania. And what has been key for all of these listening tour events has been that the local legal community has come together and taken the lead to help ensure free and fair elections in their states. And it's no different here in Wisconsin. So I wanted to give you all a little background about the ABA Task Force for American Democracy. As I was preparing for my term as ABA president, I was thinking about what issues should be the focus of my term. And I kept coming back to what I think is the single most important issue facing our country today: threats to democracy. And the facts, they are sobering. 1 in 6 U.S. adults cannot name any of the branches of U.S. government. Less than 1/3 of millennials consider it essential to live in a democracy. Approximately 38% of Americans support authoritarianism as a response to the direction of democracy in the United States. And nearly 1/4 of Americans say they are prepared to resort to violence if their desired candidate loses. As these statistics indicate, we're living in a time where the lack of basic civics knowledge, let alone how a democratic form of government differs from an autocracy, has weakened our democracy, threatened the rule of law, and put the possibility of politically motivated violence on our radar screens. Earlier this year, the ABA launched its 6th annual survey of civic literacy, and one statistic is particularly noteworthy. An eye-opening 74% of U.S. residents say American system of democracy is weaker than it was 5 years ago, and that the main cause for the downward spiral is the spread of misinformation and disinformation. The survey also asked, who is responsible for safeguarding democracy? I wonder if you can guess. A quarter believed it is the judiciary's responsibility. Only 1 in 5, about 20%, said it's the duty of public officials. And more than a third believe that all of us are primarily responsible. So it depends if you're an optimist or a pessimist. So if you're a pessimist, you say, oh my gosh, only about 20% of people think that our elected officials are responsible for democracy. If you're an optimist, though, you say, you know what, I think the survey respondents got it right. We all are responsible for preserving our democracy. So in response to all of this, the American ABA Task Force for American Democracy was created, and I could not have picked two better co-chairs. Secretary Jeh Johnson, who's with us today, and Judge Michael Ludig. And both Secretary Johnson and Judge Ludig did not hesitate even for a second when I asked them to lead this important work. The task force has produced working papers on many topics, sponsored webinars, and following the listening tours, and it's going to be the same in Wisconsin, next step committees have been set up, and you'll hear more about that later today. The importance of today's event has been clear for the past few years. We can all remember the vivid images on the assault on the Capitol on January 6th. But in the last few months, we have seen events taking shape as this election season heats up. For instance, like with robocalls created with artificial intelligence, discouraging people from voting, and other misinformation online. So I'm reminded of what historian Ken Burns told graduating seniors this year. He said, in January 1838, shortly before his 29th birthday, a tall, thin lawyer, prone to bouts of debilitating depression, addressed the Young Men's Lyceum in Springfield, Illinois. At what point shall we expect the approach of danger? He asked his audience. Shall we expect some transatlantic military giant to step the earth and crush us at a blow? Then he answered his own question. Never. All the armies of Europe, Asia, and Africa could not by force take a drink from the Ohio River or make a trek on the Blue Ridge. If destruction be our lot, we must ourselves be its author and finisher. As a nation of free men, we must live through all time or die by suicide. As Ken Burns remarked, it is a stunning, remarkable statement, one that has animated my own understanding of the American experience since I first read it more than 40 years ago. The young man was, of course, Abraham Lincoln, and he would go on to preside over the closest this country has ever come to near national suicide, our Civil War. And yet, embedded in his extraordinary, disturbing, and prescient words is also a fundamental optimism. Because we all believe in our country, the rule of law, and our democracy, and because we are all fundamental optimists, we are all here today. So today, you will hear about the state of democracy, what lawyers can do, and the work of the ABA Task Force for American Democracy. Let me introduce our co-chair. Jeh Johnson has served as Secretary of Homeland Security, as General Counsel of the Department of Defense, as General Counsel of the Department of the Air Force, and he's currently in private practice with the firm of Paul Weiss, where he started his law practice. He's also a member of the Board of Directors of Lockheed Martin, U.S. Steel, MetLife, and the Council on Foreign Relations, and he is a trustee of Columbia University. So without further ado, I present you Secretary Jeh Johnson. Thank you.
Thank you very much, Mary. Good morning, everyone. Good morning. It's nice to be back in Wisconsin. It's been a number of years since I've been in Wisconsin. Wisconsin is the place where, in the summer of 1970, my career as a baseball player began and ended at Chicago White Sox baseball camp near Appleton, Wisconsin. I arrived in Appleton determined that I was going to be a left fielder for the New York Mets, replacing Cleon Jones, and I left realizing I could not hit a curveball. So I decided to try something easier like law and public service. I had an unremarkable flight here directly from LaGuardia Airport this morning. It's always nice to have an unremarkable flight to get where you're going. Occasionally, I encounter as a private citizen, I left office 7.5 years ago, but occasionally over the last 7.5 years, I encounter TSA at an airport that we're never told that I am no longer Secretary of Homeland Security. So, fall of 2021, I was at Reagan National, waiting in the TSA pre-line, minding my own business, and there's a video of the Secretary of Homeland Security. If you see something, say something. And all of a sudden, I'm reading my iPhone, I hear my voice. Hi, I'm Jeh Johnson, Secretary of Homeland. And it's me on the video. This is 4 years after I've left office. And the people in the line are, and I'd say, hey, what do you want from me? And then I, of course, got to the TSA inspector, lower your mask, name, driver's license, please. And I said, I couldn't resist. I said, look behind you. Anyway, thank you all for being here today on this important topic. It's an election year. I'm a Democrat, but I speak to you today not as a partisan Democrat, but as a partisan American. Our American democracy, as you heard from Mary, is under threat, stoked by false and irresponsible rhetoric from those in political life today, along with deep fakes, cheap fakes, and wild conspiracy theories that go viral on social media in an instant. Increasing numbers of Americans distrust our democracy and doubt the rule of law. The danger signs cannot be denied. More than a third of Americans believe that the 2020 election was stolen. In fact, despite the challenges of COVID and the record number of Americans who voted, the 2020 elections suffered few, if any, irregularities. The best evidence of this are the over 60 court rulings across the country that found no irregularities or issues. There are no court rulings to the contrary. More broadly, recent polls reflect a widespread American disillusionment with our democracy. A Gallup poll indicates only 28% of U.S. adults are satisfied with the way our democracy is working. A Pew Research poll indicates a full 63% of Americans have not too much or no confidence at all in the future of our U.S. political system. Another poll indicates 52% of young adults have little to no trust in government institutions. Of greater concern, among Americans, there appears to be a rising, dangerous, and naive fascination with alternate forms of government. Leading the way are certain political leaders who openly express adulation for anti-democratic foreign leaders such as Hungary's Viktor Orban and Russia's Vladimir Putin. Approximately 38% of Americans support authoritarianism as a response to the direction of democracy in the United States, and less than 1/3 of millennials consider it essential to live in a democracy. The strains of our democracy erupted onto the national stage on January 6, 2021, as everyone knows, when an insurrectionist mob stormed the U.S. Capitol in a violent attempt to stop the constitutionally prescribed process for the election of the next president. There is evidence of related plots to subvert the 2020 presidential election results at the state level, resulting in state-level criminal prosecutions in Georgia, Michigan, Nevada, here in Wisconsin, and Arizona. State election officials and workers at all levels have faced scorn and physical threats simply for doing their jobs and refusing to bend to political pressure to do otherwise. Alarmingly, a significant number of attorneys joined in these criminal efforts. Former Mayor Rudy Giuliani my former boss when he was U.S. Attorney in New York, has been disbarred by the state of New York for false and misleading public statements about the election. And Giuliani and other attorneys are named defendants in some of the criminal cases I mentioned earlier. Today, in 2024, the climate is no better and may be worse. A host of candidates and incumbent office holders have already questioned the 2024 elections even before they've occurred and have refused to commit to accepting the results. Since the 2020 election, threats of and harassment directed at election workers have actually risen. Certain polls indicate that nearly 25% of Americans say they are prepared to resort to violence if their desired candidate in the next election loses. There is only one conclusion that can be drawn. Our democracy, once considered the most durable on the planet, is not as strong as we thought, and there are those who seem determined to push it to the breaking point. The time for answers and action is now. History shows that on the journey toward a more perfect union, a giant step forward is often followed by a reactionary step backward. But the long arc of history and our destiny is forever upward. In his final inaugural address in 1945, just 3 months before he died, Franklin Roosevelt said, "Sometimes we will be rising to the heights, then all will seem to reverse itself and start downward. The great fact to remember is that the trend of civilization itself is forever upward. That a line drawn through the middle of the peaks and the valleys of the centuries always has an upward trend." But, in my view, FDR's words are by no means inevitable. We must work hard to push the boulder upward on that straight path through the peaks and valleys. We must face the warning signs about our democracy head on. At this juncture in American history, the future of our democracy depends on what we do to combat growing levels of American anger, apathy, ignorance, and indifference. Bar associations like this one are the key, in my judgment. As you heard from Mary, upon taking office in August of last year, she announced the creation of our ABA Task Force for American Democracy, to be chaired by Judge Michael Luttig and myself. In my post-government life, I can think of no more important project. The task force we lead is a bipartisan group of distinguished Americans consisting primarily, but not exclusively, of lawyers. One member of the task force is here in the front row. Thank you for your service, David. The task force includes practicing attorneys, retired federal and state judges, law professors, law school deans, Republicans and Democratic election law experts, Republican and Democratic former candidates for president, a retired three-star admiral, commentators, scholars, historians, and leaders of public interest organizations. The members of this diverse and distinguished group all joined because of their common devotion to preserving and strengthening our American democracy. The task force has taken on an action-oriented operational role to meet the urgency of the 2024 election, a little over 3 months away. This work has involved immediate steps to educate, motivate, and support the work of lawyers, public officials, and election officials around the country in the run-up to the election. It includes listening tours like the one here today. The response to our efforts has been incredible, as we encounter many others concerned about the future of our democracy who want to join forces with us. On August 2nd, we will present our report to the ABA convention in Chicago with a number of long-term recommendations for reform to bolster our democracy. We must never take for granted the virtue of living in a free democracy. Democracy is like water. You don't appreciate its critical importance until you're thirsty, or your land is scorched by wildfire. Democracy is like oxygen. You don't wake up each day thanking God for the air we breathe, but if someone tried to take it away, you would be desperate to keep it. Democracy is freedom, and the most basic human instinct is to seek freedom. Thank you all very much. I look forward to our discussion this afternoon.
Well, the table has been set. Our first presenters will talk us through both federal and state constitutional issues related to election law. We have Dean Dan Takagi, and I'm looking, and there he is, and Professor Rob Yablon. Come on up. Dean Takagi is the Fred W. and Vi Miller Dean and Professor of Law at the University of Wisconsin Law School. He has published over 50 articles and other scholarly papers on issues of voting rights, free speech, and democratic inclusion. He is co-author of Election Laws, Cases and Materials. When I read that, I immediately ported back to law school, and I got a little, and the author of Election Law in a Nutshell. Professor Rob Yablon is an associate professor at the University of Wisconsin Law School and faculty co-director of the law school's State Democracy Research Institute. His research interests include election law, state and federal constitutional law, and the state and federal judiciaries. Before joining the UW Law faculty, he was a practicing attorney, and before that, a law clerk on the U.S. Court of Appeals for the Ninth Circuit and on the U.S. Supreme Court for Justices Ruth Bader Ginsburg and Sonia Sotomayor. Dean Takagi, you're going to kick us off with federal election.
Yes, thank you so much, Michelle. Well, thanks to you, thanks to John, thanks to the ABA and the State Bar of Wisconsin for hosting us. I will say it's really an immense privilege to be in a room of people who care deeply about our democracy, and not only that, are committed to doing what they can to strengthen it. These are indeed worrisome, if not perilous, times for our democracy, and it's especially important that we as lawyers stand up to defend democracy and the rule of law. I sometimes joke that this was especially around the time I started my job as Dean of University of Wisconsin Law School in 2020, that, people would come up to me because, of course, when I started that fall, the election was going on here. We are a quintessential swing state. And I would often get the comment when people found out that my main area of research focus is election law. Well, it must be so exciting in these times to be focused on election law with all that's happening. And I see my old friend Dave Becker laughing over there. We've been in this field for quite a long time. And I actually said, well, to be honest with you, it's actually kind of a relief right now that I've started this new job as dean of the law school, because I don't have to think about election law all the time, and I'm actually working on problems that at least sometimes I can solve. There are times in which the problems in our democracy do seem so large that they may be overwhelming. What I'm going to try to do in my remarks is say a little bit about how we got here. And, I think the bottom line that I really want to emphasize in my remarks is that over the past 24 years or so, we have made some really significant improvements to how elections are run and administered in this country. At the same time, there's no getting around the fact that there is a real crisis of confidence, of trust in elections and in democracy itself, as the first two speakers have already illuminated. So I'll say a bit about this as well, but I'm going to go back in time a little bit and review what's been happening over the past 24 years ago, and then I want to look forward a bit. But I actually want to start not exactly in the middle, but at a place, well, 4 years ago, with what happened in the 2020 election and the events that followed that election, including the insurrection of January 6, 2021. A couple of election scholars who I greatly admire, Nate Persley of Stanford and Charles Stewart of MIT, have written of what they call the miracle and tragedy of the 2020 election. The miracle is the fact that with all that was going on in 2020, we ran an incredibly successful election. Turnout was at record levels. Over 2/3 of people, of eligible voters that is, actually showed up to vote. That is a remarkable number for the United States, higher than it has been in over a century. And not just that, we managed this massive transition from in-person voting on election day to other means of voting, including a substantial increase in absentee and other forms of remote voting. I mean, this was really an alarming feat in the dog days of the pandemic that we, and by that I don't mean people like me who are scholars studying elections, but people in the trenches. I saw Kevin Kennedy here a few minutes ago, former who used to run elections here in Wisconsin. There are lots of people who have contributed to this immense improvement. And it's especially true if you compare what happened in 2020 to what had happened 20 years before, right? Where, whatever your partisan affiliation, that election in Florida was a real mess. Right? And Florida was not alone. Most of us in this room are old enough to remember that. We had outdated voting equipment. We had registration lists that were often a mess. We had people sometimes being purged from the rolls inappropriately, if not unlawfully. We didn't have provisional voting in most places. In a lot of places, we didn't even have statewide voter registration lists. And of course, that election resulted in the Supreme Court, or was resolved, I should say, by the Supreme Court decision in Bush versus Gore in 2000. A very controversial decision, although I would argue, the basic principles of equality underlying it, whether or not you agree that they were faithfully or properly applied in that case, are beyond question accurate, or ones that we subscribe to, right? Equal weight to each vote, equal dignity to each voter. I mean, these are fundamental principles of our democracy. What was different about Bush versus Gore is that it applied those principles to a recount process. In ways that many people found dubious, and I don't particularly want to get into the pros and cons of that decision. What's significant for our present purposes is that it opened up the courts, and especially the federal courts, for lots of lawsuits challenging the way that elections were being run, including inequalities in our election system. And I will be honest, at the time, I was an ACLU lawyer in Southern California where we were still using those punch card voting machines. I saw it as a real opportunity, an opportunity to use litigation to force some improvements in our election system. And that's what happened. And not always through litigation, and in some places through legislation. There were a lot of laws that were enacted, including ultimately at the federal level, a truly bipartisan piece of legislation that, today it's almost inconceivable that something like the Help America Vote Act of 2002, modest as it was in some respects, could get enacted. But the Help America Vote Act, or HAVA, as we election law geeks refer to it, it did make some improvements. It made some money available for voting technology improvements. Jurisdictions ultimately got rid of their punch card and lever voting machines that in many ways were less reliable, moved to either optical scan or electronic voting systems. We made great improvements in our registration lists. We have universal provisional voting across the country now. There were a lot of good things that came out of the Help America Vote Act and other changes. But of course, whenever there is dynamism in the law, there's always going to be some more litigation. And you can probably already tell, my perspective is not that election litigation is always a bad thing, right? I think whether it succeeds or it fails, it's often a good thing, right? If people have legitimate claims founded in evidence, it's appropriate for them to bring those to courts and for courts in our adversarial system to resolve those questions. And we've seen a lot of lawsuits over the years, some of them successful, some of them, most of them, unsuccessful. I was in Ohio, now a junior law professor in 2004, when Ohio was the key swing state, and we had the, I don't know if it's wisdom or good fortune, to be starting an election law project at my law school at Ohio State at the time, Moritz College of Law, just as all this was emerging. And as there were a lot of lawsuits being filed on everything from voting technology to voter ID to voter registration to provisional ballots, challenges to voter eligibility, recounts, contests, you name it. It was litigated in Ohio in 2004. And, that was, up until that point, a record year for election litigation. My co-author, Rick Hasson, has been keeping statistics on this. In 2000, there were 196 election cases brought. In 2004, that number went up to 360, which remained the high until 2020. We had a lot of lawsuits brought. It's funny, back in Ohio in 2004, some of you may remember, it was mostly Democrats who were claiming that the election had been stolen back then and blaming voting machines that they alleged were stealing their votes. And, I'm actually really proud of the fact that I wrote something then, acknowledging that there were a lot of problems with the election, in particular the way it was run by our then Republican Secretary of State, Ken Blackwell, but also saying, look, Bush won that election, and you can count up the votes that were arguably lost as a result of these problems, and you don't nearly get to the six-figure number by which Bush won the swing state of Ohio in 2004. So I'll fast forward through 2008, 2012, 2016. In each of these years, we had a lot of lawsuits brought. Not as many as in 2004, and not nearly as many as in 2020, where we'd reach a record high of 424. A lot of those lawsuits had to do with the pandemic and things that were going on during the pandemic that people were arguing, mostly unsuccessfully, but in some cases successfully, justified some accommodations under state or federal law to ensure that everybody's vote was respected. What was really different about 2024 were all the lawsuits. One scholar has counted 73 in all, brought after the election by the Trump campaign or pro-Trump plaintiffs, alleging in various ways that the election results weren't on the up and up. There were 73 of those cases, and ultimately only 2 of them succeeded on relatively minor issues. Now, there are a lot of people who will look at the conduct of folks like Rudy Giuliani and Sidney Powell, the creator of the so-called Kraken cases, right? The folks who were representing or supporting the Trump campaign in making these demonstrably false claims of election fraud. And they'll say, there go those lawyers again. I take a quite different lesson from the 2020 election. The lesson I take is that our legal system works. You can make all sorts of false claims about stolen elections in the media, on social media, of course. And you know what? As you've already heard, a lot of people will believe those claims. Try making those claims in a court of law where judges, whether appointed by Democrats or Republicans, will demand evidence, and you will have, or at least did have in 2020, a lot less success. And this is something that I think we as lawyers should be proud of. And moreover, the people who went into court, small number of lawyers, but it did happen, going into court without evidence or without viable claims, they faced consequences eventually for their actions. Rudy Giuliani was disbarred in the state of New York. Sidney Powell and others did face some significant sanctions for their conduct. Now, of course, there will always be some bad apples, but I think the big lesson to take away from 2020, not only that our election system certainly worked much better than it had in 2020, but our legal system worked as well. So, I'm going to spare you the details of the different kinds of claims that might be brought in this cycle. There are certainly constitutional claims, statutory claims, claims under the Voting Rights Act and other laws. I do want to just highlight one doctrinal point before I turn to what's to come. And that is this doctrine, sometimes called a principle, but I strenuously resist that. The Purcell doctrine comes from a case decided in 2006, if memory serves, that has made it very difficult to go into court and get injunctions close to election. It's pretty close to an absolute bar on such injunctions in federal court as that doctrine has developed. And in my view, this is a doctrine that has been very harmful because, of course, a lot of times things happen close to an election. People's rights may at least arguably be violated, and it's now very difficult to go into court to get an injunction. What are we looking at in this election cycle, or what should we be looking at? In closing, I'll just emphasize three things before turning it over to Rob. And one of them you've already heard about. This is a really very worrisome development. Election officials are really under siege. I mean, Dave, I know you probably talked to a lot of them in your line of work. I've talked to some. There are a lot of really good people who've left the field. And it's a great shame because, as I've already suggested, we've seen an enormous professionalization of election administration over the past 24 years since the 2000 election and Bush versus Gore, right? I really do believe this is an area, although seldom noticed, in which we've made great strides. And a lot of people have quit their jobs because it is not only not a lot of fun to be an election worker or an election official, but it's often quite terrifying, right? Especially in some swing states where people face really significant threats of violence. This is a very worrisome development, although one that doesn't get as much attention as it should. Second is, of course, a loss of trust in our election system fueled largely by misinformation and disinformation spread via social media and sometimes through various other forms of media. It's a real problem, and I wish there were some easy answer. But we live in a world in which it's the sort of old saw that civil liberties lawyers like me used to say, the remedy for speech you don't like is more speech, doesn't always work. Right? And I don't have a great solution to that problem, but it's definitely happening, and it is fueling a loss of trust in our election system. And the third is actually something that I've been working on for a long time, the impartiality of election officials, and particularly those at the state level. This is something I've been concerned about going way back to 2000 and 2004, where there were a lot of questions, and legitimate questions, about decisions made by Katherine Harris in Florida, by Ken Blackwell in Ohio. You can certainly point to at least arguably partisan decisions made by Democratic election officials as well. We have elected secretaries of state in most states. Not here in Wisconsin. But there is an inherent conflict of interest when a state's chief election official is elected as a candidate from their party and is subsequently supposed to be impartial in the way that they oversee elections. I think this is a real problem. I think it is certainly not the only thing or even the main thing that fuels distrust of our system, but it certainly doesn't help. And most other countries have systems of election administration that are more impartial, more independent in many ways than ours is. So I've been banging this drum for a long time, with relatively little success, I will say, until recently. And in fact, here in Wisconsin, we were until a few years ago the only state to have a truly independent system of election administration with our Government Accountability Board, which Kevin used to run. That went by the wayside. I still think we have a better than average system of running elections with our elections board, which is effectively a bipartisan board with an appointed director. But this is an area where on a national basis, I still think we have a lot more work to do. So thank you again for participating. And now let me turn it over to Rob to give you a little Wisconsin flavor.
All right, thank you. So let me just second Dan's words of thanks to the organizers of this event, to all of you for coming today. And our plan, by the way, is to try to leave a few minutes for questions at the end, so I'll try to stay on time. Dan focused mostly on federal law, federal actors like the U.S. Supreme Court, and it is natural, first and foremost, to think about when you're thinking about election law, the U.S. Constitution, federal statutes like the Voting Rights Act and the Help America Vote Act, household name decisions like Bush versus Gore. In the U.S. Constitution, federal statutes, they supply a hugely important set of rules and protections in the election space. And I don't mean to diminish their significance at all in my remarks, but that federal law and those federal actors really are just the tip of the iceberg when it comes to elections. As most of you know, elections in this country, including federal elections, are run at the state and local levels, and they're governed most directly by state constitutions, state statutes, state regulations. And the majority of election litigation that happens in this country is not in federal court, but it's in state court instead. And Dan gave some numbers about election litigation, numbers that folks like Rick Hasson have put together. Some of my colleagues at the State Democracy Research Initiative at the University of Wisconsin Law School have done some of this research too. So first of all, as Dan noted, there's been a rise in election litigation across the board. There is 4 or 5 times as much litigation as there was in the pre-Bush versus Gore era. And there's been an uptick just in the last few years. But not, if you don't think just about the volume of litigation, but where it's being filed, we've seen in particular a rise in litigation in state courts. And so if you look at, say, filings in 2022, which I believe had the most litigation of any midterm election in U.S. history. 70% or more of those cases were in state courts, not in federal courts. And so why is that? Why are we seeing more attention among lawyers to state courts? Well, partly it's a function of federal courts actually directing some of the action to their state court counterparts. Sometimes directly, if you think about decisions from the U.S. Supreme Court, like Rucho versus Common Cause, basically saying the doors to federal courts are closed if you want to bring a partisan gerrymandering claim. Where should you go instead? Go to state courts. And many litigants have done that. Right. There are other instances in which the U.S. Supreme Court in particular has sent a message, sometimes implicitly, sometimes more directly, that they are not going to be particularly amenable to, say, federal constitutional claims about burdens on voting. The bar to win those claims is high. Doctrines like the Purcell principle, or doctrine, if I can't call it a principle, that Dan mentioned, discourage federal litigation, particularly close to an election. And so, again, where do you go instead? You go to the state courts. So in addition to some of these claims being essentially redirected to the states by the federal courts themselves, I think there has been a gradual awakening on the part of lawyers to what is in state law, in state constitutions, and they've realized maybe more than they had in the past that state constitutions, state statutes, they're really an untapped resource for those who are seeking to protect the right to vote or to ensure that rules are being followed. Right. And, if you think about legal education, again, it is by and large a national curriculum that we teach, particularly when you're on the public law side, even beyond election law. Federal constitutional law classes are ubiquitous. State constitutional law, not so much. And so there is an educational process that's kind of gradually happening, and people are becoming more attuned to the possibilities that are in their own state laws and their own state courts. This is true of the public at large as well. I mean, this might not surprise you. Most people don't even realize what is in their state constitutions, or even that their states have one. There was a survey from Johns Hopkins a few years ago where more than 50% of Americans didn't understand that their states had a constitution, which is pretty striking in particular because in many of these states, voters are being asked on a regular basis to vote on amendments to those constitutions. So what do they think that they're voting on, right? So when we're talking about elections in particular, state constitutions have a lot more to say than the U.S. Constitution does, it turns out. My colleague and spouse, Miriam Seifter, who's a professor at the University of Wisconsin Law School, and another colleague, Jessica Bullman-Posen at Columbia, wrote a piece in the Michigan Law Review a few years back called The Democracy Principle in State Constitutions. And their bottom line is that state constitutions provide a, quote, stronger foundation for protecting democracy than their federal counterpart. They found that in terms of text, history, and structure, these state constitutions events interrelated commitments to popular sovereignty, majority rule, and political equality. And if you start to actually read what's in state constitutions, which many of us never have taken the time to do, you find some remarkable stuff in there. Nearly every state, for example, has an operative provision of their constitution that's a popular sovereignty provision that's really committing to popular self-rule in language that sometimes echoes the language of the U.S. Declaration of Independence, but never made it into the U.S. Constitution itself. So if you look at Article 1, Section 1 of the Wisconsin Constitution, it says, quote, all people are born equally free and independent and have certain inherent rights. Among these are life, liberty, and the pursuit of happiness. To secure these rights, governments are instituted, deriving their just powers from the consent of the governed. And so you're getting right in that first provision of the Wisconsin Constitution a sense of what kind of system we have. Right, and nearly every state constitution, including Wisconsin, has affirmative and express guarantees of the right to vote that go beyond what you see in the U.S. Constitution. Many of these constitutions, including Wisconsin's, devote an entire article to suffrage. It's Article 3 in the Wisconsin Constitution. It comes even before the Constitution describes the legislative power, the executive power, the judicial power. It first affirms that this is a system in which the people broadly have a right to vote for all of the offices that are later delineated in the Constitution. Right? It defines the electorate broadly in Section 1 of Article 3. Every United States citizen age 18 or older who is a resident of an election district of the state is a qualified elector of that district. Right? It goes on to guarantee the right to a secret ballot, and it recognizes that elections and voting is something that needs to be operationalized by legislation, and so it affirmatively authorizes legislation for residency, for absentee voting, and so on. And in fact, Wisconsin law does a lot of that operationalizing. 8 full chapters of the Wisconsin statutes are election law. That's 250 plus sections of statutes, many subsections. Right? And among other things, those statutes create the Wisconsin Elections Commission, which in turn does its own additional regulating and creating guidance documents that are trying to interpret and implement what's in our election laws. Article 3 of our Constitution, by the way, as some of you know, was amended most recently just a few months ago. Voters voted to amend it to prohibit the acceptance of private donations, grants, and assistance by elections officials. And that the genesis of that kind of came in the wake of the 2020 election, where there were concerns by some about private grants that were made to elections officials to help them administer the election during the pandemic. And so one thing to keep an eye out for in 2024, this will be the first election cycle in which this new constitutional amendment is in effect, and there are some questions about its scope, in particular the part of it that says that you can't accept private services. Well, how broadly does that sweep? Because election officials need help from other local officials to administer elections. Sometimes they just want to call an election machine vendor to troubleshoot. And there are at least some lurking questions about the extent to which this new constitutional amendment may impact their ability to do that. There are also questions about whether I think this is a self-executing provision. There's no legislation yet to implement it. And there may be some questions that we see down the road about whether this provision actually now is creating an implied right to some level of public funding. If you can't privately fund elections, then is that a way of saying that there actually has to be formally a state commitment of at least a minimum amount of funding? Well, so that's some of what we see in the state constitution, and that's some of what we then see litigated. I mean, there are also state constitutional provisions that address the districting process. Some of you are familiar with these. Article 4 of our Constitution sets criteria for our legislative districts. And again, this is common to state constitutions around the country. And then if you look at the rest of the state constitution, what do we have in our state system? You know, we have elections for every branch of our state government, legislative, executive, and judiciary. And we have them without the representational distortions that people sometimes complain about at the federal level. Neither Wisconsin nor any other state has representation allocated in the way that the U.S. Senate is, right? It is all representation allocated by population at the state level. We don't have an electoral college in Wisconsin or any other state. We don't have a life-tenured, unelected Supreme Court. So we have a measure of electoral accountability even for our judicial branch, and that is the most common way that states do things around the country. So, you know, that is the state constitutional system that we have, and we've seen prominent state constitutional litigation in recent years in Wisconsin. I mean, one of the highest profile state constitutional cases in the election space recently has been our redistricting litigation, initially after the 2020 census and then again in the Clark case this past year. The upshot of that litigation determined that the maps that the state Supreme Court adopted initially after the 2020 census violated the contiguity provision of our state constitution. So a state constitutional holding. The state suggested that we needed new maps, and if the court was going to draw them, the court said it was going to take partisan balance seriously. That prompted the political branches to then adopt a map of their own. So again, what is the bottom line? We have new state legislative maps for 2024, and so something, again, to look at is how those maps operate. When we have more competitive districts than we've had for a long time, the possibility of a real battle for control, partisan control of the state legislature, and when we have more closely contested state legislative races, right? We sometimes talk about the closeness of our statewide elections in Wisconsin, but we have the potential for a lot of local district recounts, a lot of very close races where there's going to be wrangling potentially over every vote, partly as a result of these new maps that we have. Well, we've also seen some state constitutional litigation concerning the right to vote, right? And this is true, again, not just in Wisconsin, but around the country, as people have turned away from federal claims, thinking that there's maybe more promise to make state-level claims. We've seen in recent years in Wisconsin, I would say, only a fairly modest amount of this state constitutional right to vote litigation. Partly that's a function of the fact that we've had divided government in the state for the past few years, so we haven't had a lot of new election statutes that have been adopted that we've then seen constitutional challenges to. In the past, the Wisconsin Supreme Court has described our state constitutional right to vote in very grand terms, right, and described an expansive right that Wisconsinites have. I mean, there's a 1949 case, State ex rel. Frederick versus Zimmerman, where the court described the right of a qualified elector to cast a ballot for the election of a public officer which shall be free and equal, is one of the most important of the rights guaranteed by the Constitution. If citizens are deprived of that right, which lies at the very basis of our democracy, we will soon cease to be a democracy. For that reason, no right is more jealously guarded and protected by the departments of government. Right? So that suggests that you might well get very robust protection of the right to vote. Sometimes that's been true in Wisconsin, sometimes less so. There have been decisions where the Wisconsin Supreme Court has more or less lockstepped with what you might expect from a federal court. That was true a decade ago, for example, when the Wisconsin Supreme Court upheld our state's voter ID law. But it's possible that we will see additional state constitutional claims. Some of these are pending now. There's a case right now in the lower Wisconsin courts called Disability Rights Wisconsin versus Wisconsin Elections Commission, where you have a claim by Wisconsin voters with disabilities that prevent them from reading or marking their own paper ballots. And they're raising some federal statutory claims, but they're also raising Wisconsin constitutional claims, and they seek to require the WEC to provide them with electronic ballots that will allow them to use an e-reader to vote independently in ways that they otherwise can't currently. And they invoke the secret ballot protections of the Wisconsin Constitution as well as the Wisconsin Constitution's Equal Protection Clause. A state trial court recently granted a temporary injunction, partly in their favor, and that case is now pending on appeal. Right? And so, again, we may see more litigation along those lines, state constitutional right to vote litigation in Wisconsin. The majority of the election litigation that we see in Wisconsin, though, actually isn't constitutional, but actually sub-constitutional wrangling. And the most common type of assertion that you see in these cases, there are a number that we've had in recent years, a number that are pending now, more that we might see in the future. It's essentially that regulations and guidance from the Wisconsin Elections Commission or the practices of local election administrators is contrary to what Wisconsin statutes provide for. Right? So the complaints are that elections aren't being administered in proper compliance with the statutory law. If you think back to 2020 and the lawsuits that were filed by the Trump campaign and some of its allies in Wisconsin, it was mostly this type of claim. Right? There were claims trying to, say, strike in-person absentee ballots on the ground that there hadn't been proper written applications submitted within the meaning of Wisconsin statutes. There were claims made that the Democracy in the Park events that Madison held, for example, were not statutorily authorized. Right? So statutory rather than constitutional claims. Those claims that I've just described, by the way, and a couple of related ones proceeded to the Wisconsin Supreme Court after the election in December 2020. And the Wisconsin Supreme Court rejected them under the doctrine of latches, which is an important doctrine related in some ways to the Purcell doctrine that Dan mentioned earlier. And that doctrine is one that says that relief in election cases shouldn't be available to people who sleep on their rights. If you have a complaint about how elections are being administered, you should make it when you know you have it, rather than waiting until after the election and springing it. And so what the Wisconsin Supreme Court in that case said is that the Trump campaign essentially slept on its rights. It knew that these things were happening, didn't challenge them until the results were known. And at that point, the court said it was too late. People had relied on these interpretations of the law, and you couldn't, after the fact, disenfranchise people who reasonably cast votes based on the guidance that was in effect at the time. And so the doctrine of latches may end up being, as it was in 2020, a protective doctrine if there are late-breaking challenges in 2024. Right? There are still some unsettled issues in Wisconsin concerning absentee voting, some pending cases that I won't get into detail on now, but you're actually going to hear on the next panel, I think, from some folks who are directly involved in litigating some of these cases. Again, cases about absentee balloting. The one thing that I will mention briefly, because it is the most recent word on election law from the Wisconsin Supreme Court, which was the Priorities USA case decided just last week. This was, again, a statutory case, not a constitutional one, but it was the case that restored the possibility for local election administrators to provide drop boxes, overruling a case 2 years before that had said that those drop boxes were not statutorily authorized. And so something, again, to look out for as the election approaches is to what extent will drop boxes be back? How many local election administrators will choose to use them? What will be some of the safeguards that are in place surrounding them in 2024? So why don't I go ahead and leave things there so we do have at least a few minutes for folks to ask us questions.
If you have questions, pass them to the end, and we will pick those up and see if we can pose them. While we're
Looking for questions. I'll look to the. I've got a question. You both have talked about the different ways in which cases come through the courts, and noted that state constitutions are a little bit different everywhere, which in itself may be confusing or create some misinformation. If I'm reading the news or listening to the news on TV and I hear this is what happened in Wisconsin, but there's a different outcome in a different state, what thoughts do you have about how we can communicate that difference state by state and why the outcomes of different cases or cases may be different based on state constitutions?
Yeah, I mean, it's a great and tough and tricky question, and it relates to some of the stuff that Dan was getting at, and I think panelists will get into later about how do you deal with misinformation, how do you get reliable information out there. I think when you're dealing with state constitutions and state level litigation, it's one of those areas where you ought to think about local coverage and your local media rather than just kind of the national picture, and hopefully we will be able to have folks who are covering the election locally who are able to convey some of that. But you're right. I mean, there are common threads in state constitutions, right? So every state constitution really has these robust protections for the right to vote. But, I mentioned that the Wisconsin Constitution was just amended. So now, you can't accept private donations for election administration. The Michigan Constitution literally constitutionalized, voters there constitutionalized in 2022, the opposite rule, protecting the right of local governments to accept private grants for election administration. And so the dynamic in that state is going to be very different, and that's just something that is going to need to be communicated to people.
Right. Likewise, I think there were some early decisions on drop boxes that said they were perfectly fine, yet the early decision in Wisconsin was that they were not constitutionally permissible. Right. If you were a betting person, where do you think most of the litigation will arise? Under federal constitution issues or state constitution issues? Yes.
I'd say we're more likely to see state-based litigation, either constitutional or statutory. I mean, we'll see some federal cases, I'm sure, but the Supreme Court has made it more difficult with the Purcell Doctrine to bring those cases close to an election, which we really now are. We're close to the November election, so I would expect to see more litigation in state courts overall than in federal courts.
Yeah, the one wrinkle that I'll add to that is that neither Dan nor I mentioned the independent state legislature theory, which is this sort of looming thing at the U.S. Supreme Court. There was a case called Moore versus Harper. We won't get into all of this recently, which shut down the broadest conception of this independent state legislature theory. But the court in that case suggested that the federal constitution places some constraints on state courts to go beyond the bounds of ordinary judicial review, whatever that is, when they're interpreting their own state laws and constitutions. And so, you may have a lot of action at the state level, and you may have some parties that then try to run to the U.S. Supreme Court to say, what the state court just did here goes beyond the bounds of ordinary judicial review, and so now that's a federal issue that you, the U.S. Supreme Court, or another federal court need to jump in and deal with. And so we may see at least some of that in the coming months.
And it probably will not surprise anyone in this room to learn that the United States Supreme Court has, through that language Rob just quoted, given itself the space to act as the final arbiter of federal elections, even in rulings that are based entirely on state law. Shades of 2000, indeed.
I'll ask one final question, and then we're going to take a little bit of break. Dean Takaji, you mentioned an inherent conflict of interest in our elected officials being declared of one party or another. What would it take? Is it even possible, in the realm of possibility? And who's discussing that issue or working to have open dialogue on that issue?
Yeah, I mean, there has been some progress in the sense that there are at least some groups that are more active on the issue of independent or impartial election administration since 2000. The Election Reformers Network is one that has in particular made this their issue, but it's not the only one. What would it take? I think in most places it would take a state constitutional amendment. We don't have an initiative process for doing that in Wisconsin, but many states do, and that's probably the most likely road to getting more independent or impartial election administration at the state level.
We will stop there. Thank you very much, both, for your federal and state views. We will take a short break. There is sugar, and by sugar I mean cookies, out in the atrium there, and we will resume at 1:50.
Thanks.
Thank you. makes its way up to the front, I'd like to just take a minute and acknowledge that we're very fortunate to have lots of wonderful people in attendance, but there's a particular group of people that I personally want to thank, and that is past presidents of the State Bar of Wisconsin. I would ask all of our past presidents of the State Bar to stand. I believe we have with us Pat Ballman, Pam Barker, Fran Deisinger, Chris Rogers, Margaret Hickey, and Diane Deal. And John Skilton, Paul Swanson. Of course, you're always, and Dean Dietrich. He's almost not even past. It's like days. And Dean Dietrich. Thank you for being here. May still be outside. We are also joined today by former or retired Supreme Court Justice David Prosser, Justice Prosser, and current Supreme Court Justice Ann Walsh Bradley. Our next panel, having talked about federal and state constitution and litigation, our next panelists have actually done the litigation. I'm going to turn things over to one of our host committee members, Joseph Dietrich from Husch Blackwell, who will introduce our panel to talk about the nuts and bolts of election litigation.
Thank you very much, Michelle and John and all of the host committee, as well as everyone speaking and attending today, both in person and online. I know we have a number of folks watching, so thank you for tuning in as well. So as Michelle mentioned, we're going to transition a little bit with this panel from theory and a high-level discussion to in the weeds discussion about what it's actually like to live in this space of practicing election law. And I make no claim to doing that myself. I'm a litigator and an appellate litigator at Husch Blackwell, but the two folks to my right are litigators themselves at different law firms, but they both spend a substantial amount of their practice doing election law. And so, as brief introductions, and I'd welcome them in their answer to my first question to introduce themselves further if they would like. But Erin Deely, to my right, is a partner at Stafford Rosenbaum, where she joined in 2023 and practices trial and appellate litigation. She's also co-chair of the firm's election and political law team, and she argued before the Wisconsin Supreme Court twice this past term, both in election-related cases. She's also was recently named a 40 under 40 by the In Business Madison magazine in 2024, and she's a member of the James E. Doyle American Inn of Court, the Dane County Bar Association, and the State Bar of Wisconsin. And then next to her is attorney Misha Tsaitlin, where he is a partner at the Troutman Pepper law firm based in Chicago, but lives in Madison. He's a former Solicitor General of Wisconsin, and he's currently the chair of his firm's appellate and Supreme Court practice group. After law school, he served as a law clerk to both a judge on a U.S. Court of Appeals as well as a Supreme Court justice. I'm forgetting that at the moment who you clerked for, Misha, but please inform us once I turn it over to you. He's also a recent and frequent arguer before the Wisconsin Court of Appeals, U.S. Courts of Appeals around the country, and the U.S. Supreme Court. So my first question to the both of you is, when we talk about election law and specifically election litigation, what kinds of disputes more specifically are we talking about? And I'll ask you first, Erin, sort of what does that mean to you? And again, welcome you to add any details about you and your practice in answering that question.
That
your introduction was pretty thorough. I was an appointed attorney for Governor Evers for 4 years, his first term. And before that, I was actually a public defender. I was an appellate level, a public defender in Milwaukee. And before that, I was a trial level public defender in Illinois. So it means a whole host of things. Many of them we won't have time to get into today. I mean, when people say election litigation, people will sometimes think about redistricting. I don't think we'll discuss a ton about the redistricting case today, largely because we need probably the full set of time for the afternoon to really do it justice. But there's also the Chapter 5 WEC complaint process. You might consider that part of the sort of landscape of election litigation. And then there's, of course, all the things that Professor Yablon talked about and Dean Takashi, the federal and state disputes, increasingly state disputes over constitutional and statutory provisions. I don't know if I missed anything.
Yeah, me should go ahead and add to that list, and then I also wanted to just prompt you briefly to sort of situate the redistricting process in the context of election law.
Yeah. So first of all, I was the way I came to Wisconsin. I was State Solicitor General of Wisconsin for a couple of years, and I clerked for Justice Kennedy before that. So along with those cases that Aaron was talking about that lead up to elections, the other aspect of that you can have an election litigation is after the election. You can have recounts and things of that sort. If you all remember back to the 2016 election, when I was State Solicitor, we were there was a request to do a recount by the Green Party that involves some, and there'll be recounts and those kind of things, and those are also within the rubric of election litigation that I've done and that my firm does. What was the other aspect of your question?
Oh, so in addition to completing that list, just when we talk about redistricting and apportionment types of cases, do you consider that to be sort of bread and butter litigation, or is that or election litigation, or is that something different?
Yeah, I guess if you want to situate election litigation on a continuum, at least when you're talking about state legislature or congressional, first you got to redistrict. You got to draw the lines where the folks are going to be running under. Then the folks that run might have some issues with their election compliance, and then they'll be dealing with WEC or the FEC. Then the rules that govern the election, that's some of the stuff that was talked about before with, voter ID, absentee voting rules, and then after the election, there can be recounts. All of those processes involve both, advice on the front end of how to do it legally, how to do the redistricting legally, how to comply with WEC or FEC rules legally, how to draw statutes that comply with federal law and the state constitution. And then once that happens, there can be litigation. There can be litigation over whether the maps that you drew comply with the state constitution or federal law, whether you adequately complied with WEC or FEC requirements on candidates, whether your statutes are constitutional or lawful, and also, recounts can also lead to litigation about the standards of recounts and things of that sort.
Good. Perfect. I think you heard Secretary Johnson and Michelle at the beginning recite some statistics about how Americans view their responsibility and particular government actors' responsibility for deciding the rules of the road when it comes to elections. And if I'm remembering correctly, it was 20% to the judiciary. And so, with the previous panel and with this panel, we're talking a lot about how things operate within the context of the judicial branch, and we're probably doing that a lot because we are lawyers and that's the way we've been trained to think. But no doubt the outcomes we talk about here in this panel set the rules of the road, not just for the judiciary, but for the entire system. But to the extent we're focusing on the judiciary and on the litigation process, the two folks to my right are part-time election litigators. They're both private practitioners at law firms. And so the next, real topic I want to introduce and then turn it over to you is, when you're comparing election litigation work to the other types of litigation and legal work that you do, how is it similar? How is it different? How do you approach election litigation cases? And what does that mean in the context of your broader legal practice? And feel free to take a very personal spin on this if you'd like. Erin, go ahead.
Well, first I want to go back to the stat you started with, which and tell me if I'm misstating this, but it's that 20% of people who are polled considered jurists as the proper person to identify and establish the rules governing,
to safeguard democracy.
To safeguard our democracy.
Yeah.
Okay. I think that's what I thought you first said was rules of the road, and there might be some conflation there, and I thought that was really interesting because, and really interesting in the context of our election system, which in Wisconsin is enormously decentralized, and we by nature of our system, we have over 1,800 clerks in our state. I think the state of Wisconsin has about 1/6 of all the clerks in the United States. I mean, that's incredible. So and then they're, informed, and their practices and determinations are informed by WEC. So I'd be curious to hear what jurists have to say about it, but I think they would probably prefer to be the last people to have the say of what the rules of the road are, and under a more, in our particular system in Wisconsin, what we're dealing with right now, which is divided government, there would be an ideal world in which a lot of the changes and rules of the road were established through the political process and legislation. So that's just a side observation. Maybe Misha has some comment or response to that, or some insight to provide as to the difference of election litigation to other litigation. For me, I have noticed the pace to be the most significant factor. It is truly dizzying, incredibly fast, the way election litigation transpires. And I can speak more specifically on a case maybe later in the presentation. But that to me is an extremely startling difference.
Yeah, I mean, obviously that last difference is probably the most significant. You'll, in a normal case, a normal commercial case, you get a complaint, you get, time to answer it, get an extension for an answer. Maybe you have a motion to dismiss that fails, then you have discovery. You get a trial date set a year from now, and you go through discovery, things of that sort. In an election case, especially one that a party is attempting to litigate either in the midst of an election or on the eve of election, you'll often be moving much faster than that. A lot of times, I remember we had a lot of litigation. We have a lot of litigation during COVID, both before the state Supreme Court election in April and before the general election in November. And in all of those circumstances, the entirety of the cases were essentially litigated on a preliminary injunction posture. The first filing was a complaint, but it was accompanied by a PI. There often wasn't even time for any meaningful discovery. There wasn't a time for depositions. Sometimes there's not time for expert reports. The way it works in the usual context is sometimes you seek a PI. I do litigations where preliminary injunctions or Wisconsin temporary injunctions, state courts are sought all the time, but they're really a prelude. Like I was arguing a preliminary injunction yesterday in Denver in a religious liberties case, and a lot of the discussion with the court was, this is the evidence we have now of religious discrimination, but we're going to depose the town and we're going to figure this out, but give us some temporary relief now so we can house these homeless people on in our church. But everyone knew that it was the first step, and we're going to have lots of litigation afterwards. In an election cases, like all the 2020 election rules of the road elections with regard to litigation with regard to COVID, you had the PI, you had a decision, and those were mostly in federal court. You had a decision from the district judge on you'd have an oral argument on the PI. You'd have the emergency appeal to the Seventh Circuit. We had a couple of emergency appeals to the U.S. Supreme Court, all on the PI posture, and then the cases just end because the election is over. Especially in that circumstance where COVID wasn't going to continue, the conditions that were justifying some of the relief sought weren't going to continue. So you have everything is truncated. It's not ideal. I think it's one of the reasons that courts have developed certain doctrines to encourage lawsuits over election rules to be brought earlier rather than later, because it's really not a great way to run litigations where where the courts are jammed up, forced to make decisions on hugely important issues that determine how our democracy can be run, without the testing of all of the facts and the legal issues that would normally percolate in a normal case where you've got quite a bit of time to develop it.
Yeah, I think one of those, I think it was DNC Bostelman, was from time of filing complaint, and this was one of the 2020 COVID cases, from the time of filing the complaint to, making it to the Supreme Court, U.S. Supreme Court, I think it was under 2 weeks. I mean, there was one case that was under 2 weeks.
Boston was a little bit longer, but just in a couple of months, we went from district court for preliminary injunction hearing, where we, by the way, both sides submitted something like 400 pages of cross motions. Then went to the Seventh Circuit. Then we had an emergency certification to the state Supreme Court. Then it went back to the Seventh Circuit. Then the Seventh Circuit issued a decision on the PI. Then went to the U.S. Supreme Court, all in a couple of months. And that was
the fall. But in the spring, the pandemic didn't start until mid-March 2020, and that spring election was the first week in April.
Yeah,
so
that was
right. I hate to say the word again, dizzying, but it's wild. And as a litigator, I think anyone who litigates can appreciate the stress of the time markers in the practice, and it's an extremely stressful type of practice, and then you just put it on hyperspeed, and that's election litigation.
But it's not only stressful; it's so high stakes. Obviously, you care about all your cases, you want to do your best, but it's not lost on you that these are the rules of the road for our democracy, and if you want to do your best job you can, and you do the best job you can, and the judges are always doing the best job you can, but things are rushed, and you can't, nobody can do something as well in a week as they can do it over 6 months, and so that adds to the stress on the entire system, which is why courts have developed certain rules to try to tamp that down when you can. Obviously, when a pandemic hits, there are things that need to be challenged in short order or whatever.
Mm-hmm.
So I would like to invite everyone, as we did for our last talk, to ask questions, to write those down on those pieces of paper that are around, or any piece of paper that you may have in front of you, and we can get those in front of our panelists at the end. I'll also say, especially for anyone in the room who's not a lawyer or who's a law student, and I know there are a few, if some of the concepts that we're talking about are perhaps a little bit technical, don't be afraid to ask those questions either, because I think we'd like to walk through exactly what we're talking about and why it matters. And on that note, I want to move to the next question that I've told you about a little bit ahead of time. I'm going to ask each of you to pick one or two specific cases, election cases, that either you've done, you've worked on, or that you just know about and that you feel comfortable talking about. But really walk through from beginning to end, and whether that's over a 2-week period or over a year period, walk through sort of the process of what happened to some level of granularity, so we could really understand what it means to litigate an election case. And either one of you, please go first.
Yeah, so since I already gave a little preview, I will talk about the case that known as DNC versus Bostelman. This was a series of challenges to various Wisconsin election laws for the 2020 general election in the era of COVID. And most of the challenges had to do with rules for absentee voting, because absentee voting became a lot more popular and desirable in light of some folks' discomfort in voting in person during COVID. And so the lawsuit was filed in federal district court, and there were actually 3 or 4 lawsuits filed challenging various aspects of Wisconsin election law. I represented the Wisconsin legislature. We intervened to defend those state laws. The RNC also intervened. The Wisconsin Elections Commission was represented by the Wisconsin Department of Justice, which in that circumstance took the position that it was unable to litigate to defend state law, a position that it hasn't taken in other cases. But in that case, they said, we're not here to defend state law, we're just here to represent the commission, and the commission's evenly divided. So we had, lots and lots of briefings submitted on on basically the preliminary injunction posture. Lots of, from the 3 or 4 parties, they submitted their briefs saying various number of state election laws needed to be enjoined in whole or in part in light of COVID. We submitted a over 100-page opposition. They had declarations supporting their preliminary injunction. We had declarations supporting our opposition. Then they filed their reply briefs. Then we had basically a half-day oral argument in front of Judge Connolly, where the press was listening. I remember this was this time of COVID, and I was like doing the argument on Zoom, and I was like trying to keep the background clear, so because I knew the press was on. It was crazy. And so then the judge issued a decision that enjoined some laws, didn't enjoin others, but we're in the middle of election, so we had to take an emergency appeal to the Seventh Circuit. So the Seventh Circuit then holds that the legislature and the RNC do not have standing to appeal to defend state election laws, at which point we sought en banc rehearing from the full Seventh Circuit to overturn this. Then at the same time, we filed an emergency motion for original action in the state Supreme Court, because the issue of whether the legislature had standing to defend state law is an issue of state law. In response to that, the en banc petition, the Seventh Circuit certified the question of whether we had standing to the state Supreme Court. The state Supreme Court then ruled that we did have standing. We then returned to the Seventh Circuit, which, having previously said we had no standing, now having been told we had standing, ruled for us on the merits that we were entitled to a stay, at which point the parties who had challenged the state laws did an emergency application for a stay to the U.S. Supreme Court, and the U.S. Supreme Court ultimately upheld the Seventh Circuit in all respects. All of that happened in I think, a 2.5-month period. We went through 3 different levels of federal appellate court, 3.5 if you count our en banc petition, and we got to the state Supreme Court all in one case, all in a short period of time. So that's obviously a bit of an extreme example. Not all state election law cases go all the way to the U.S. Supreme Court or have this many steps, but this kind of thing can happen. And it was very fun and stressful.
It was very fun.
Misha, just one question for you, since Dean Takagi brought it up a moment ago. Was the Purcell principle or the Purcell doctrine involved in that case or not?
So one of the arguments that we made successfully to the Seventh Circuit is that the changes were coming too close to the election, and then under the Purcell principle, the the federal courts could not make these kind of changes in state election law. We won in the Seventh Circuit on that basis, and the writings of the U.S. Supreme Court also largely revolved around that principle. There's obviously an analogous principle that has been invoked at times at the state court level as well. But the personal principle in particular is often thought of, and I think correctly, as the relationship between the federal courts and states. It's only by analogy where it's brought into state court, where the state courts sometimes, and in Wisconsin, have developed a similar principle when you have requests to change election laws to state courts.
Great. Yeah, thank you. Erin, what's your war story?
I didn't bring my own because I just didn't want to, too close to home. But just similar, sort of pandemic related. But I think the Tigan case, that is the Dropbox case, heard in 2022 by the Wisconsin Supreme Court and overruled last week in Priorities USA. But that had a super fast pace as well. That was from the point of the issuance of the court's ruling up to the Supreme Court, a really truncated timeline. Interestingly enough, in that case, the court seemed to have bypassed a temporary injunction, issued an oral ruling, and then a week later issued a permanent injunction and a written ruling, and that was appealed and bypassed to the Supreme Court. I want to be really conscious of time. What time do we have to go?
We have till 2:30, so please.
Vast acres of time.
I have some other questions, but.
Right. And so in that particular case, it's just an interesting case in that from the injunction point to the final resolution and conclusion of briefing to the Supreme Court, it was similarly really speedy. And I don't think that's an aberration, where I do think the case that, Misha just went through is was unique to the circumstances of COVID, whereas in state court litigation, I think that pace was a little bit more representative of what you might see normally in state court. I'll spare additional details for now.
Sure. And one question to you. So I think you already answered it, which is that was a case that rose starting at a state trial court and then eventually up to the Wisconsin Supreme Court. Depending on how well folks are plugged in, you probably heard about the original action procedure being used in election or election-related cases. Without having to get into a particular case, can you maybe just comment on the difference between the type of case that rises through the levels of courts versus an original action? Just explain what that means.
I'm not sure I'm quite answering your question, but I do think it's interesting, that the concept of original actions, the increase in original actions during recent periods in Wisconsin is definitely not something you see in the federal courts. I think Professor Alan Ball from Marquette does a really impressive accounting of, the increase, especially during the 2018 to 2022 period increase in original actions. And that's especially for law students here, that's a really unique aspect of Wisconsin state law. Offhand, I'm not thinking of election cases that have been brought and heard original action.
Well, there's definitely at least one, which was when Governor Evers attempted to move the April Supreme Court election because of COVID. That was brought as original action. And, one can, debate the merits of, the increase of original actions. But, I think that case well illustrated the beneficial use of original actions, because whether the election primary, whether the state election for the state Supreme Court and other races was going to be moved was an issue of statewide importance. If something like that happened at the federal level, what you would have is you would have whoever wants the relief, they'd carefully pick out their plaintiffs. So they'd be able to pick out a district judge that they would be more likely to get their relief from, and then you would have that decision, have an emergency appeal, and you'd have, it would be, it's sometimes very challenging, and it creates a real first mover advantage for those who are plaintiffs. Whereas in an original action, the court that ultimately is going to decide the issue of statewide importance, you just go to them, and you just whether the decision is right or wrong is decided by the state's highest court, and you don't have a first mover advantage like you do sometimes in federal court. You often have in federal court where you can pick your venue, and and all responsible plaintiffs do pick their venue very carefully when you have optionality.
Thank you, Misha. I'm going to do one more of our planned questions, and then we have a number of questions from the audience that we'll be able to get to. So both of you, like I've said, are private practitioners at law firms who do election litigation sort of part-time. But you've both also been attorneys for the government in the past, whether it be in a Solicitor General role or a Counsel of the Governor role. And so you've both had the opportunity to engage with clients in a really different way in matters and in representations that are impactful for our democracy. Could you comment on what it means to you as a lawyer, as a member of the lawyerly profession, to be able to work on election cases? Do you view it as just another client? Do you view it as part of a larger project? I don't think there's a wrong answer to that question, but I'm sort of curious to know what your perspective on that is. And feel free, either of you.
I mean, I view it as a great privilege. I feel it, for me personally, it's an extension of public service. Previously having been a public defender and previously having, worked for an elected official, and I think it's a type of service, and I love to do it. I see the courts and litigation as a vehicle for especially with what we're talking about today, which is this rise in a lack of faith in democracy and a lack of trust in our institutions. I think that it can be a vehicle for, maximizing participation in democracy and maximizing our faith in institutions. So it is very different in a lot of practical ways, but I enjoy it for a lot of the same ways as well.
Yeah, I mean, obviously it's high stakes. It can be stressful and very enjoyable. But when you're a lawyer and you're advocating for a client, you definitely want to feel like you're making what you're doing matters. It matters to people. It matters to your client, and it matters more broadly. And ultimately, these decisions, when you're in election litigation, the decisions that shape our democracy are made by the judges. You are playing a role, an important role, but it's really a role to help the system work, where the judges are the ones that are making the decisions. So you feel like a great responsibility to present your side of whatever the election controversy is in as fulsome and powerful manner as possible, so that the judges can make the right decisions. Because, it's really easy as a lawyer to get worked up, like, oh yeah, Aaron, you beat me last week in a case or whatever. But ultimately, I
did beat him. I beat him twice.
Absolutely. There's other cases you win and you lose, but it's not actually a sport. It's not like when you go out and beat somebody and tell us you're like, I defeated you, therefore I'm like better than you. You're part of a system, for a system, our adversarial system of litigation to work. Both sides have to present their arguments in the best, most forthright, most zealous manner possible, so that the judges, who are actually the ones that are making these decisions, can make the right decisions to set the rules of the road for our democracy. And while, you said that 20% figure, certainly responsibility, is diffused throughout the system. But when legislatures make laws, when election officials make decisions, they're making them in the shadow of law. And the law is shaped by the decisions that are made in these cases that we litigate. And so it's important, while you're in the maelstrom of these fights, to remember you're doing a part in something very important, but you are only doing one part. And, I try to keep that in mind.
I almost sort of disagree a little bit.
Okay.
I guess only to the extent that that's right. I mean, absolutely, the most fulsome, the most, we wanted to have the most robust and comprehensive presentation to the court in making their decisions. But I also think we have great responsibility in, if you're a private litigator, in the choices of work we do, I think that is it's maybe not as significant. It is a very significant responsibility, and we're just not like mules for the best argument.
So with that commentary, much appreciated, I do want to address a couple of questions from the audience, starting with a question from Secretary Johnson. He asks, so to promote efficiency and confidence in election litigation results, what do you think of 3-judge panels to decide questions at the trial court level? I think this would be asked of both the federal and state systems. But if either of you have thoughts, by all means.
Yeah, so the way it works at the federal level is if you have certain election law disputes and you're raising constitutional challenges, it goes through a 3-judge panel. But if you're raising statutory challenges, then it goes to a traditional 1-judge. And in my experience, I haven't found that the quality of the litigation or the decisions is that different between the 1-judge and the 3-judge panels. There is a benefit sometimes when you have an ideologically diverse 3-judge panel and you have a dissent, like we had in the McGill v. Whitford case that went up to the U.S. Supreme Court. But in general, I think the 3-judge panels, I don't know that I found them to be all that different practically from the 1-judge ones in terms of, usually in the 3-judge panels, the 1-judge is kind of running the show. They're the ones that are kind of making sure that the trains run on time and things of that sort. And I don't know. I haven't found it to be that meaningfully different.
Erin, any thoughts on that?
No, I will defer to Misha's assessment of that. He has more experience with the panel.
So another audience member asks, we sometimes see last-minute poll closing matters, disputes that arise on election day at the polls themselves, land in a court or before a judge. And the question is, how does that work? And I think maybe the first question is, have either of you dealt with an election day of matter, or that you're capable of commenting on that?
I mean, the first thing I would recommend to practitioners who plan to possibly take cases from election day is know your duty judges in the respective counties that you might litigate in, because how you get a hold of them, how you identify them is all going to be very different, and you want to know well in advance. I haven't done day of, but I've done a recount, and that was, in very short, a very condensed timeline after the election. But
yeah, I mean, I've been on standby, but luckily I have not had to actually do a day of. That seems like even more stressful than the stuff I was talking about right now.
So I know that there are a couple of questions that we weren't able to get to, but if you're able to hang around, I don't know if our panelists are, I won't speak for them, but I know a number of us are going to be hanging around for a reception afterwards. I'm sure we'll hear more about that in the coming minutes. In the meantime, I want to thank Misha and Erin both very much. Let's give them a round of applause.
thank you both, all three of you, but the practitioners sharing your I don't know how you would do that in that time frame. That just seems craziness. But then again, I'm a transactional lawyer, so. Our next panel is going to be hearing directly from our election administrators. We have David Becker, who is the Executive Director and founder of the nonpartisan nonprofit Center for Election Innovation and Research, working with election officials of both parties all around the country to ensure election voters should trust and do trust. A key element of David's work with the center is managing the election official legal defense network, providing pro bono legal assistance to election officials who are threatened with frivolous criminal prosecution, harassment, and physical violence. I'm going to let David introduce our election officials, but they're going to walk us through the actual mechanics of our election process. David?
Thank you so much, Michelle. And thanks to you and to the State Bar for hosting today. This has been so informative already. And thanks to you, Mary, and the ABA for organizing and sponsoring the task force on which I'm honored to serve under the leadership of Secretary Johnson. Thank you, and to Judge Ludig, who've put so much time and effort into this important issue. I'm joined today by Lisa Freiberg, who is the Fond du Lac County Clerk. Hope I said Fond du Lac right. Did I? Okay, good. I'm not from Wisconsin, so apologies. And also by Lindsay Mather, who's the Assistant City Attorney for Green Bay, who will talk a little more. We're going to get into these nuts and bolts issues about how elections are run. But before I start asking them some questions, I want to put this all into context. 44 months ago, this country held the most secure, transparent, and verified presidential election in its history. And that's not just my opinion. That is objective fact by every measure. It's the opinion of the Trump administration DOJ and Attorney General. It's the opinion of the Trump administration Department of Homeland Security. It's the opinion of campaign staff for the Trump campaign. It is the opinion of his own White House counsel, his own family. And as was discussed earlier, it was the opinion of dozens of courts all over the country, including at least 8, by my count, judges appointed by the former president himself. There were recounts all over the country. Georgia famously counted its presidential ballots 3 times, 3 different ways. Once entirely by hand, all coming to the same result. And as probably people here in Wisconsin are well aware, the losing candidates have an absolute right to a recount also in the state of Wisconsin, as well as Michigan and Pennsylvania. And in 2020, the losing presidential candidate, unlike in 2016, where, as was noted, the Green Party candidate requested and paid for recounts in all 3 of those states, the losing presidential candidate in 2020 requested statewide recounts in none of those states, only requesting recounts in 2 counties in this state, Dane and Milwaukee, confirming the results. We sit here now, 44 months since that election, and there's still not been a shred of evidence presented to any court anywhere in the country that would cast any doubt on the outcome of the 2020 presidential election. And think about how remarkable that is. This 2020 presidential election has withstood more scrutiny than not any election in American history, than any election in world history. Every time the question about this election has been raised, every time it has been put to the courts, every time courts have requested evidence to be subjected to cross-examination and scrutiny, every time those who have claimed that there was a problem with the 2020 election have not only failed to present evidence, in some cases they've outright run away. in Rudy Giuliani's defamation case, where truth would be an absolute defense, he conceded liability. In a lawsuit in Arizona brought against the former gubernatorial candidate, she conceded liability in a defamation case. Fox News settled the case against a voting machine company for nearly $800 million, rather than have to fight out liability in a court of law. There are organizations who have been very active in spreading lies about the election on social media and in so-called documentaries that, when pressed for evidence, have again run away, have conceded that they had nothing. Republican attorneys general in Georgia and Arizona requested one such organization to present evidence because they wanted to investigate further, and that organization said, we don't have anything. Admitted in court that they had nothing. Dan referred to the idea that the 2020 election was a miracle. And in some ways that's right. But a miracle just happens, and this did not just happen. This was due to hard work and diligence by principled people like the two people to my right, and so many thousands upon thousands of their colleagues all over the country. Somehow, in 2020, and I think Aaron referred to this, think about here in Wisconsin, try to put yourself back in that first week of April of 2020. Yours was one of the very first primaries. Yeah, don't stay there for too long. The happy hour reception's coming later. That's probably a better time. But yours was one of the very first primaries. And it did not come off without a hitch. Everyone was trying to figure it out. And then think about how successful the November election was, how those lessons were learned. In the United States of America in November of 2020, we managed the highest turnout in American history by every measure. Dan mentioned this, 67% of all eligible voters voted. We had not seen that since the 1880s. And that ratio was not so high because the numerator was high. It was because the denominator was a little bit lower in the 1880s. Not everyone had the right to vote as we have it now. We had 20 million more ballots cast in November of 2020 than had ever been cast in any election in American history. And that was all done and survived all this scrutiny because election officials went to work. And you can't run an election socially distant. You can't do it by Zoom. They were in their offices. They were in their warehouses. They were in their polling places. Even if voters chose to vote by mail, as many did, or vote early, as many did, they were in their offices. And I'll tell you, I talked to many of them during that time. A lot of them were getting sick. And again, go back to November 2020. We did not have vaccines back then. We didn't fully understand the virus. We didn't understand really how it was communicable. And they did their job anyway. After that election, honestly, we should have thrown a parade for people like this. And instead, they've been subjected to 44 months of nonstop abuse, threats, and harassment. Not because they did a bad job, but because they did an amazing job that has withstood all this scrutiny. So we're going to tell you a little bit about that job. Aaron also mentioned this. We talk a lot about litigation. I'm also a former litigator. I'm a lawyer. And often it's easy to think about how the law applies and how litigation can relate to some of these things. But actually, so much of election administration has gotten right because of hundreds of thousands of public servants. And especially here in Wisconsin, where elections are so decentralized and so complex and so narrowly decided, at the statewide level at least, that it's an incredible achievement that it's done as well as it is. If you want to take an easy bet someone that the Wisconsin presidential race is going to be decided by between 20 and 25,000 votes in 2024. because it's always decided by between 20 and 25,000 votes. It's going to be very close here, and that's not a sign of something going wrong. It's a sign of a very closely divided electorate in this state and something going very right, that the ballots can be counted as verifiably as they are. So we're going to talk a little bit about that right now. So I think there are three main areas that we want to discuss in terms of the nuts and bolts. The voter registration process, getting on the list so you can vote in the first place. The casting of the ballot process, what happens when voters cast a ballot. And then finally, the counting and certification process, where we transparently show who won and certify those results. So let me ask you both. Let's start with voter registration. Wisconsin's kind of a unique state with regard to voter registration. It's one of this, I think many of you know, one of the few states that's not subject to the National Voter Registration Act because it has same-day voter registration. And it strikes me, working all over the country, that Wisconsin's actually a state that has remarkably accurate lists, given how mobile Americans are. About a third of all Americans move within a given 4-year period of time, and many of those people move multiple times. So maybe both of you, and Lisa, why don't I start with you first? Talk a little bit about how the voter lists are maintained, to what degree you have confidence in those voter lists, and the process of voter registration, how easy it is, and how much security and integrity it has.
Well, Wisconsin does maintain a statewide voter registration system. It's WisVote right now. I've been with elections for 26 years, so we've gone through many different types of statewide voter registrations. But going back to when I first started with the county, it was basically when you showed up at the polls, you might be on that list that the county generated. If you weren't, you just put down Lisa Freiberg, my address, and that's how you registered to vote. Fast forward to today, you are in that system. And when people do come in to register to vote, now it's pretty much on the municipal level or possibly in the county level for those that allow it on the county level, but you are put into a system. And if you are registered somewhere else, that's what you are looking for. So we'll type in somebody's name and address, date of birth, driver's license number, and it will pop up. There is a match in Brown County. And we look to make sure so that we can bring your registration over. On the registration form in Wisconsin, it does provide where you were last registered at. It's amazing how people don't remember where they were last registered at. And so we do look at that too, because we have multiple names. We have juniors, we have seniors, so on and so forth in the state. So we want to make sure that we are bringing your correct roll over. We run into a lot of problems with our college kids that register here, they register at UW Green Bay, they register at UW Milwaukee, on and on. And as a really good administrator is going to do is check, because you might have multiple people. Same with marriages. You know, our dream in this world would be when people move, one of the things they think of after 28 days of being in their new location is, hey, I got to register to vote so I don't have these problems. Once again, same day registration, 28-day residency. It's amazing when people move to other states and they realize, guess what? They had to be there X amount of days before they can vote. So all of a sudden they have the intent to return back to Wisconsin so that they can get that ballot in Wisconsin. So that leaves a lot of criticism also on the afterwards of, oh, we're illegally letting people that moved out of the state allowed to be able to get a ballot sent to them into their new state because they have the intent to return. And that's where sometimes it falls into legal hands to make sure that is correct. We can only do what the law allows us to do, and that's when I say call your legislators to make that change. Same day registration, that is where we hear, okay, I'm looking at my numbers just today. I have 56,941 registered voters in Fond du Lac County today. In November of 2020, I had 57,451 people vote. So right away, people say, oh my gosh, she's inflating the rolls, right? We're all inflating the rolls. this is not all these people that register on election day, because of course people wait until that last minute, realize they don't look ahead of time that they move, they don't realize, oh yeah, that's right, I moved, I need to register to vote. So that is where we hear that. Our numbers are always lower before any big election. Right now, the movers cards are being sent out to people, and although housing, and we don't see that movement as much, but right now, for my 21 towns and 9 villages, I do all of their work in the system for them. My 21 towns do not have a full-time clerk, not a single one of them. Fond du Lac County is a bigger county, but they don't have full-time jobs. I mean, they have full-time jobs, but not as the clerk. Even my 9 villages, only about 6 of them have a full-time clerk. Once again, Fond du Lac County. So I do my office does all the voter stuff in the system on behalf of them. We are seeing a lot of cards coming back of people that moved. So now we have that ability to inactivate those people out of the system. So I'm starting to see that little bit of decrease. But with the April 13th, August 13th election coming up, we also are seeing people taking that responsibility and registering. So though I love numbers and statistics, so I've been really watching these numbers and documenting more and more, because I know what's going to happen in November of 2020 or 2024, or I feel I know, and I'm going to be documenting a lot of these numbers as I go along.
Lindsay, before I get to you, I forgot to mention we're going to be doing questions at the end of this as well. So find a piece of paper, find a card. If you have any questions about the election process in Wisconsin or anywhere else, good time to write it down. We'll have plenty of time. We're going to try to leave plenty of time for questions. Lindsay, you've seen this from the municipal level as well.
Yep.
And I think what a lot of people don't recognize, and you heard a little bit in Lisa's comments, are the variety of checks and balances in place to make sure a record represents a legitimately eligible voter and is accurate at the time of the election. So, for instance, Dan again mentioned getting into the election nerd stuff, the Help America Vote Act, or HAVA, which Wisconsin is subject to, unlike the National Voter Registration Act, and maintains statewide voter registration lists, but also required voter ID effectively for all voter registrations. Every single voter in the United States in federal elections provides ID in order to get registered. Can you talk a little bit what you're seeing at the municipal level and the checks and balances in place to make sure that every voter, for instance, same-day registrants, what they have to do to get registered on election day, it's not just showing up and saying, give me a ballot, right? Can you talk a little bit about some of those protections?
Yeah, certainly. I will say, as a municipal attorney, I'm a little bit more removed from that part of the process than our clerks or our chief inspectors or our election inspectors who are actually there doing the actual processes on the day. As a voter, it's particularly same-day registration. If you want to sign up at the polls, you have to have your ID with you and proof of residency that you have lived in the jurisdiction for at least 28 days. Like Lisa mentioned, the intent to return for absentee ballots. I'm moving off of voter ID a little bit here, but let me back up a second. When you request an absentee ballot online, you are also supposed to provide a copy of your ID, so that there's checks for voter ID for absentee voting as well. And certainly, if you do in-person voting, you have to present your voter ID or your ID to do that as well. But with respect to things like the sufficiency of your ID, or that you've lived in the jurisdiction long enough, or if you're voting absentee, that you do have that intent to return, those types of things are subject to challenges by election observers. So if somebody, if you did move to a different state and you're not going to be there 28 days before the election, and you say, well, I have a intent to return to Wisconsin just so that you can still vote in the election, and an observer or anybody really challenges that to the clerk, they would have to do that when the absentee ballot is being counted, but if the clerk determines that there's a process so that an observer or an individual can raise a challenge to that voter's credentials or their ability that they don't reside in the state anymore or intend to return or whatever the cause may be. And if the clerk or the board of absentee ballot canvassers or whomever, depending on how the ballot's being counted, if it's at the polls or if it's central count, if they believe that beyond a reasonable doubt that person isn't qualified to vote in that election, the clerk can not count that ballot. So there's not just with respect to the ID, but with respect to any of the qualifications to vote, there are abilities for people to challenge those and for those voters to essentially their votes not be counted if the clerk believes beyond a reasonable doubt that they aren't qualified to vote in that election.
We've talked about same-day registration a little bit here, and one of the things that struck me in my research across the country is the states that have same-day registration, most people think of it as new people coming in and getting on the list and voting that day. The vast majority of people who are using same-day registration in most states, and I see you nodding because I was about to ask you this question, are existing registrants within the state who moved since the last election. And to your point, Lisa, you were mentioning this, people, when they have a life event like a move, people often don't think to update their voter registration. They might go to motor vehicles, for instance, and update that information, but they usually wait until an election, which means you're going to get a whole bunch of either last-minute address updates or same-day registration address updates at the last minute. I keep seeing 75% of about in other states with it are about our existing registrants, so not new people getting on the list. Is that consistent with what you're saying?
It's very consistent. Another thing that comes up is the 4-year purge. When somebody in the state of Wisconsin has not voted for 4 years, they are sent a card that just says, hey, and I'm exaggerating a little bit, but hey, you haven't voted in the last 4 years. Do you want to continue to be on the rolls? In today's society, and not even today's, but not so long ago, people take that card and whip it out. Well, what's it to them until they show up at the polling place on election day, and guess what? They're not on the list, and they give the election officials a little bit of a rough time. Where election officials call me, oh, well, looks like they haven't voted for 4 years. They need to re-register. So that we're seeing, and where I really saw it was back when all the recall elections were happening and where people were coming literally out of the woodwork to vote. Our numbers went really, really up. It's funny that this question comes up because just yesterday, one of my new municipal clerks said, as I had a training with them in April, was you're going to see them coming out of the woodwork, out of the caves and holes in the ground, and they're not going to know that they have to have picture ID to show at the polling place. So I had a clerk that had somebody that she didn't realize they were not registered to vote for a long time. Yesterday, I had a truck driver who came in and wanted to register to vote because he needs to vote in the big election. So it's they are coming out, and I truly believe that we are going to see people that have not voted in many years come out and vote in this election for either side or for that third party choice too that's out there.
Lindsay, do you have any thoughts on that particular point, or?
I would just echo those same sentiments.
So back to one of the challenges we were facing, this problem of last-minute updates or last-minute getting on the rolls. Wisconsin has been, for several years now, a member of ERIC, the Electronic Registration Information Center. I will admit to not being completely unbiased about this because I led the effort to create it, and I'm very proud of it. And about half the states in the United States are in ERIC, but it has been subject to a disinformation campaign lately. And for those of you who aren't familiar, ERIC is a consortium of states, red states, blue states, states as red as Utah and South Carolina and Kentucky, and states as blue as Oregon and Connecticut and Illinois. And they share securely some of their data to find out if people have moved between the states, for instance, or if they have even moved within a state to send that information back to the states so that they can reach out to them in between elections, not before. What's your experience been with that? And have you found it to be useful and maybe even cutting down some of the same day registration
Well, I thank you
transactions?
for it.
Oh, well, that's good.
For leading and Wisconsin being part of it. I've always appreciated knowing that. I am very close with a group in my county or in the city of Fond du Lac, actually, that don't believe elections are run securely, so on and so forth. Whenever I get our ERIC updates, and I am always more than happy to show, obviously not giving names, but look at these are this amount of people that are now taken off, inactivated. They're not taken off. That is another conspiracy. They're inactivated in the voter system, in the Wisconsin statewide voter system, that they are now in another state, and that there isn't that opportunity for them to be able to vote in Wisconsin and another state. We recently found where somebody in Fond du Lac County did vote in 2 states. They didn't realize that they couldn't do that, moved to Michigan or whatever. So they did vote twice. But if we would have known that, we could at least inactivated them from our roles. So yes, I think it's great. Anything, not that I want to take anybody's right away to vote, but I also look at it on the other end that we are helping them that, oh yeah, maybe I did vote somewhere else, because it seems a lot of people have short-term memory on elections, especially in Wisconsin. When you really think about it, how many elections we have in Wisconsin, sometimes it's just that continuous circle of elections, and then we have our special elections and recall elections and everything else that's going on that people don't even realize what ballot. Look, Milwaukee County, they have a special election going on in between, or the city of Milwaukee, or the Senate district, I'm sorry, down there. See, I can't even keep track of all of them. So, and we did have that a couple of years ago where I had our county executive passed away in office. That was an automatic special election that was also going on with the partisan primary for August of that year.
Lindsay, what's been your experience with the election officials you're working with in Green Bay?
Sure. So again, I don't have a lot of hands-on experience with ERIC. I will say during all of the litigation that Green Bay was experiencing around 2020, the mere suggestion that Wisconsin was a member of ERIC seemed to cause some heartburn for some folks. So what we did start to see was just kind of an influx of records requests of people who wanted to see the voters who were, either came up based on the updates to ERIC for each of several elections. Thankfully, we're not the custodian of those records, so we got to pass those along. But there was a lot. We had a large influx of people asking for information about it because it did become a kind of a central issue in some of that litigation.
I want to get to the public records requests in a little bit because I know that's been an ongoing issue. But let's move to the act of casting a ballot here in Wisconsin. And again, to give it some context, I think there's narratives often that voting is harder than it should be or that it's rigged. And actually, the reality is that voting is not only very secure, but it's actually more accessible than it's ever been in American history. Wisconsin, that's, I think, certainly the case. I don't know if people are aware of it, but and we put out a report on this recently, which can be found on our website, electioninnovation.org. But over 97% of all Americans have access to early in-person voting, which is the highest percentage ever. Compare that to 2000, where that percentage is about 40%. That's true here in Wisconsin, obviously. So there are now only 3 states where you can't vote early in person: New Hampshire, Alabama, and Mississippi. And 39 states, including Wisconsin, allow anyone to vote by mail. The vast majority is without an excuse. So this has been something that is a bipartisan success story, despite some of the disinformation that's been spread. Why don't, and again, I'll start with you, Lisa, talk about the variety of methods by which Wisconsinites, is that the correct term? Okay. Wisconsinites can vote conveniently and securely, and how you've seen that evolve in your county over time.
Well, start out with people that would like an absentee ballot mailed to their home can go right online now through the My Vote system and be able to ask for a specific election or for the calendar year. So right away at the beginning of the year, I tell a lot of my voters that if that's what you want to do, put that on your calendar in January to get that ballot mailed to you. So that's one option. Federal elections, 47 days or so before an election, that ballot is already being sent out to the voter. So there really is no excuse. Our spring elections, that's another story, especially with our people that go to Florida for the winter and possible 20, 21 days that we can get ballots sent down to those folks. But these municipal clerks in the state do a phenomenal job getting that right to vote to those folks. We also have the in-person absentee voting, which begins 2 weeks, 14 days before the election. And that is in the cities, that is during the hours of the municipal clerk. Villages and towns is a little bit more of a challenge because, once again, most towns and villages, villages are good, have more office hours, but in towns, it's reaching out to your town clerk and doing that in person. But once again, our dedicated town clerks in this state will do it. I have a municipal clerk that will do it on Sunday morning before the election in the church hall, because people can vote up to 11:59 p.m. the Sunday before the election. And she's Lutheran and she allows the Catholics to come and vote at the church hall because she's very proud that she does it. And you hear this statewide, these stories. You have the clerks that will do it on dump days, because a lot of towns still have dump day and recycling days and so on and so forth. Then at 7 a.m. on that Tuesday of election day, that is everybody else's opportunity to cast your ballot. And they are there from 7 a.m. Until 8 p.m. on election day to be able to come in and cast that ballot. During that course of that day, those absentee ballots that were either by mail or in person are counted throughout that day. And if it goes past 8 p.m., they will keep counting those ballots. But there are so many opportunities in Wisconsin now for that. My always biggest concern is that they get those ballots sent back in a timely manner, because nothing breaks my heart more than the day after the election when my municipal clerks are starting to call me and saying, we just received this ballot or that ballot or whatever. So that is a big concern, is getting them back to us.
And if I can just follow up on that, because we heard earlier about the recent Dropbox ruling by the Supreme Court. Can you talk about how that relates to returning ballots quickly and on time and security and all that, and how you feel about that overall?
Well, in my county, running as a Republican, obviously everybody in the room knows what the feeling is, and I totally support drop boxes. It is a wonderful, secure way of getting that absentee ballot to the municipal clerk. Whether it be at our county building, and we have a camera on our drop box that will now be reopening, but even if another municipality drops it in that drop box, the city clerk gives it to me, and I reach out to my municipal clerk and saying, hey, we have that. We stamp it that it was received in the county clerk's office, but the sooner that the voter can go on and see that their ballot is to the municipal clerk's hand and know it's going to be counted, because every voter, and I forgot to mention that, every voter that requests an absentee ballot in the state of Wisconsin is able to track that absentee ballot online. And even a step further, our legislators, and it didn't pass through, was going to set it up that the voter could get a text message when the ballot was being sent to them and when the ballot was returned to the municipal clerk through the My Vote system. I'm hoping in the next session that they will look in, or we can get that to pass, because I think that's today's technology. But drop boxes, back in 2020, when we saw the more popularity in my own, I live in a town, and they actually got a box with the old roller. I'm going to try to explain this, that once you put your absentee ballot in there, it turns, so you couldn't put your arm in there, and it went into a safe on the other end where the municipal clerk only has a key during that time. We do that for our tax payments. We do that for forms. So something as important as a ballot I certainly support all of our USPS workers out there, but let's face it, when I mail something from Fond du Lac to Fond du Lac, it's 2 to 3 days. You get to our up north counties here in Wisconsin, the mail goes to Minnesota. Nothing against our friendly neighbors, but those absentee ballots are going to another state before it comes back into Wisconsin.
Lindsay, do you have any thoughts about the Dropbox ruling and and overall the how it's going to help with the municipal clerks and their processing of mail ballots?
I think overall it's very positive. I think the clerks that want to use the standalone boxes will choose to do that. But I think it's also very important that Lisa was saying, the overnight drop boxes that clerks can feel comfortable allowing people to return ballots that way again, and that you won't have this kind of catch-22 where if somebody returns a ballot that way that it potentially can't be counted because it can't be returned to them or whatever. So I think overall it's very positive. It'll clear up a lot of confusion, make things easier for voters and clerks alike.
Yeah, and for those of you that are want a national perspective, drop boxes are non-controversial and available in almost every state. If you, as Lisa, you mentioned, they're used for all kinds of government activity all the time, and to be able to give, we won't say procrastinating, we'll say last-minute voters an option of getting that ballot back without worrying about that deadline is important.
If I
go
could
ahead,
just add, in Wisconsin, the last day to request an absentee ballot is 5 p.m. on Thursday. So if the municipal clerk receives that request at 5 p.m. on Thursday, they're supposed to get it in the mail. Well, out in the country, a lot of the post offices are only open a couple hours now, so really the absentee ballot would not be sent out till Friday. You think about it, the voter is not going to receive that ballot till possibly Monday, maybe on election day. So that there's just the timing isn't there anymore.
Yeah, I mean, and public service announcement: if you're planning to vote this year, make a plan. Don't request that mail ballot on the Thursday before the election, if at all possible. It might be legal, but that doesn't mean it's the smartest thing to do. So I want to move on now to the counting of ballots. There's a lot of disinformation spread about how that occurs. And Lindsay, I'll start with you. I think a lot of people don't recognize how transparent that process is and how many observers are watching that process, et cetera. Can you talk a little bit about what you've seen in Green Bay and at the municipal level?
Certainly. So at all polling locations, observers are allowed to attend and watch the registration process, the people signing in to get their ballots. Obviously, you can't watch somebody fill out their ballot, but they, you don't have to go as an affiliated with any particular party. You can just go and watch as yourself and observe the entire process. You can do the same thing for the municipalities like Green Bay that have what's colloquially called central count, which is where we count the absentee ballots. Rather than certain municipalities will send the absentee ballots for a particular ward to that ward's polling place and count them at the polling place. Municipalities with central count will count all the absentee ballots in one place. And if you do that, observers can watch that process as well. Also, we have poll workers who are affiliated with particular political parties, and we make sure that there are equal plus one numbers of affiliated voters at each of the polling locations, including central count. And depending on what's happening, like for example in Green Bay, we have our affiliated poll workers be the ones to go down with the clerk to the clerk's office and bring all the ballots up to the central count location. So we make sure that the affiliated poll workers are the ones involved in the moving of the ballots or the recreation of ballots that for one reason or another can't be counted by the voting machines. I totally lost my train of thought. There was something else I was going to say. We have a lot of, observer-wise, we have a lot of frequent flyers who are there for, repeated elections, and we all, get used to seeing one another. Everybody can they can ask observers can ask questions of the chief inspectors and get their questions answered. Was there something else? Some other part of the question that you asked me? I had something else that I was going to say. It was good too.
You could pause it and we'll come back to you.
Fair enough.
Lisa, do you have any thoughts on the transparency of the counting process and
the transparency is there for whether, and not even the observers, but our election officials. I was able to get a lot of our election officials that were former observers because as observers, they want to touch it and feel it. And I said, well, if you want to be touchy-feely, why don't you become an election official? And a lot of those people turned out to be very good election officials. So they're actually being part of it. The transparency all day long, every voter, whether you're there or you're the absent voter, you are given a number. And that number needs to be watched all day long on the machine. If you're at 123 and the machine better be at 123. If the machine's at 120, but there's 3 people still voting, you know you're still right on. So it's always transparency by watching all those numbers, watching what's going on. But one main thing is when you go into the state is part of the elections, then it's brought down to the county. And from the county, it's then goes to the local level. I'm one of these people that wants to be in control of everything for it, but at some point I have to pass it on to the municipal clerks. And then on election day, the municipal clerks are not in charge of the polling place. The chief inspectors are. So that you see all the decentralization and the authority on as the election process goes on. So there's so many eyes on the elections right down to, and then of course our observers. But in Wisconsin, there is only 3 types of equipment that is certified, and that is Dominion, ES&S, and a company called Clear Ballot. That is the only 3 types of election equipment that can be used in Wisconsin. But then you look at other states and the entire state is Dominion or the entire state is ES&S. So again, local control, local authority is big in Wisconsin, that every county municipality can do things a little bit different, but yet we're all following the same set of laws.
I've just been joined up here, by the way, by Kathy Bernier, who some of you might recognize as a former state senator and a former clerk who's been an incredible leader on this. And thank you for hustling over from Milwaukee, where I understand you just were a little bit ago. We're in the. I want to be a little bit respectful of time because we're going to get. I want to take some questions in a second. I want to talk about resources for a second. We were talking about that, about the laws that now prevent election officials from taking private funding, that were not balanced with a commitment to adequate public funding, and how that interacts with some of the increased burdens that you're seeing on your offices, either through legal burdens or I'm hearing consistently what you were mentioning, just frivolous and duplicative public records requests that seem almost designed to suck up your bandwidth. Can you, and Kathy, I'll give you a little chance. I don't know if you have something you want to add on there yet because you just sat down, or you want to defer to Lisa and Lindsay.
I will just comment on one thing. Private funding has never been consistent from biennium to biennium, so I don't think any municipality ever counted on private funding. I did provide a bill and proposed a bill prior to leaving that I think that it's always been that the local and county elector or taxpayers paid for local and county election administration. The state generally paid for what went on at the state level, either the GAB or the Wisconsin Election Commission. I do believe it is time for the legislature to step up and at least pay a certain amount per capita to local governments for election administration. It is not as easy anymore as just printing a ballot
and then doing a paper ballot and in the box you go. There's a lot more to it than that.
I would also say certainly Green Bay, I don't think it's any secret, was kind of featured prominently in some litigation in 2020 for grants received from the Center for Tech and Civic Life. Just as a note, we were one of 5 cities that was consistently sued for that, but there were over 200 in the state that received money from that organization. But, it's important to note, like, if there's another pandemic level event, we're going to need money. Like, that money went to pay for things like hand sanitizer and additional pens so people weren't touching the pens one right after the other, and hand sanitizer and more poll workers and hand sanitizer. I can't stress the hand sanitizer enough. And more ballots and envelopes, because there were unprecedented numbers of absentee ballots being requested, and renting new polling locations because places didn't want us to use there were unprecedented expenses, and that money was necessary, and the constitutional amendment has been adopted, and so municipalities will follow that. But importantly, that money will have to come from somewhere if there's another event like that. And so I think that the point is well taken. I think the legislature should apportion some money to help municipalities pay for those costs.
Lisa, any thoughts about that?
2 open records requests that I received already since yesterday. On the county level, I have Corporation Counsel, who just loves me during election times. We're like this. However, on the municipal level, this costs money. The towns have Matt Parmentier is what the majority of my towns use for their attorney, his firm and everything, but every attorney knows everything about elections, right? We can be honest. I mean, we can all look it up and everything else. What I do is when I get these open records requests, I know they're going to be going to the municipal level next. I'm already sending all the state statutes over to Matt, and he is then referring all of the information and your terminology on how to answer these open records requests. But that's the charges to our local municipalities that can't afford. They love all the attorneys and the legals that go with it, but you have to get paid, but they don't have this extra money on election years like this. So that would be a great source for the state. Somebody needs to fund these locals. It's the counties, yes, it's extra money. I put the extra money in, but our local municipalities really struggle during these times. And once again, these clerks, they're getting an email. First thing they do is they send it to me. Lisa, is this legit?
Sorry, just really quickly, even for those of us that do have in-house attorneys, Green Bay has 5 attorneys. We're already at 188 records requests for this year. And we haven't even, the fall elections haven't even happened yet. We're expecting that number to probably be 3 times that before the year's out. We got an unprecedented number after 2020. So even for those of us that it doesn't technically cost extra money to answer these records requests, it ties up staff people and attorneys and stops other legal work that's important to the municipalities.
Yeah, and I just wanted to say briefly, I really appreciate what you just said, Kathy, about the resources. Philanthropic funding of elections was never Plan A, nor should it be. Government should provide adequate resources to give its own citizens a voice in our democracy. And the fact of the matter is, if you look at what, for instance, your job used to be 10 years ago and what the municipal clerk's jobs used to be 10 years ago, when it was a fairly quiet, sleepy little job. It was still very busy and you worked harder than anyone realized. But now you don't only have to be election officials, you have to be cybersecurity experts, you have to be physical security experts, you have to be communications experts. You sometimes have to be mental health experts. From where we are, which brings me to kind of the last point that I wanted to raise, which is we've seen unprecedented threats directed at public servants who work in all aspects of election administration over the last 4 years. And in many ways, Wisconsin has been ground zero for that. I just wanted to open it up to see if any of you would want to talk about what you've seen either personally or amongst others of your colleagues I've heard stories of people being followed, people being harassed, certainly on social media and directly threatened with arrest. That's happened to multiple people that I know of here in Wisconsin. Can you talk a little bit about that, and feel free, I mean, if you're open to it, to get personal? Any of you want to talk about it? I don't mean to put you on the spot.
I think we've seen it on a lot of different levels. We had, a lot of poll workers are typically older folks who, for health reasons, didn't want to work the polls in 2020, and decide, because of the way that poll workers were treated during that election season, decided not to come back. And we've had difficulty retaining folks from one election to the next because of the way that interactions go with observers or with folks outside the building, and not even protesters, just people who are just passing by, and stories make the news a lot in Green Bay, and people's faces end up on the news. And we've had employees who've been the subject of harassing phone calls from people in the public. We've had certainly records requests directed at specific employees who have worked elections with, which to some extent could be interpreted as being somewhat harassing because they don't like that person's perceived politics or just their role in elections. I think our clerk's been the subject of a lot of negative attention certainly on social media, even by some of our elected officials, and it's coming at everybody from all angles. And yeah, there's mental health elements to it. I think a lot of folks who prior to 2020, their role maybe didn't, and it wasn't necessarily part of their role to be involved in elections. Like our office, the city attorney's office, is much more heavily involved in elections than it ever was prior to all of the litigation in 2020. And yeah, I think there's a lot of added stress that comes along with that. So there's the state created starting next year after the 2024 election, it'll be a Class I think, felony battery against an election official. Some municipalities are passing their own civil forfeitures for disorderly conduct against an election official because of the behavior that we're seeing directed toward these folks. These are significant problems, and it not only makes people not want to be election officials, but it undermines confidence in the elections overall. And it also, voters don't want to come in and vote in person because they're afraid that some of these more vocal election observers who may have been problematic are going to be there, and there may be some confrontations. We've had confrontations that have gotten some, pretty heated. So, it's a lot. It's why conversations like this about the health of our democracy and the realities of how transparent and well-run our elections are so critical, because there's a lot that we have to counter.
I just want to, there are a few people. I'm as notorious, almost as notorious as Robin Voss is in my party. I've been called a lot of names, including a rhino, which is the new four-letter word. Only because I felt it was important to speak the truth. And most of the backlash I received was primarily verbal. And I think that's most of what everyone has received, is the verbal assertions or accusations or that sort of thing. That does affect us, definitely. Fortunately, as far as I know, nothing actual physical attacks, and thank God. But I do want to say that in my experience, I went to the Waukesha election integrity thing last night because I really wanted to know what was being said. The good news is they're talking about election integrity and honesty, straightforward. Every legal vote should vote. Every legal person should vote. Every vote should count. And so the the message is changing among Republicans, and I'm so relieved that it is. So praise God. And so let's. You don't want to overreact. You don't want to create a fear that really doesn't exist. And so there's a fine line between creating false fear and real fear. And I'm more of an optimist, even though I've been, taken the brunt of verbal abuse by people who used to love and adore me as a legislator. So, but this too shall pass. For the most part, people will get over it and move on, and we're just waiting for that time.
Well, and I think that's largely thanks to people like you and the leadership you've expressed and the fact that you've pushed back against some of these things. Lisa, did you have any quick thoughts on this?
Nope,
Okay.
just that 33 county clerks have resigned since 2020.
And I think about the 72 clerks, right?
There's 72 county clerks, yeah.
The 49 others, because we talk about the attrition, and the attrition is real. But what's remarkable is how well the elections have been run despite this attrition, and what's remarkable is how many election officials are staying on the job despite this. I mean, I don't know if you need to know, if you haven't figured this out already, Lisa is not getting rich and famous being a county clerk. Her colleagues at the county and municipal level are not seeing a pot of gold at the end of the rainbow. If you talk to the hundreds of thousands of professional election workers all over this country, liberal Democrats to conservative Republicans, they do it not because there's of the paycheck. They don't do it because it's a cushy job. It isn't. It is a hard job where they are working long hours, much more than 40 hours a week, all the time. They do it because they got into this job, usually by accident, and found a calling. And they give us all our voice. And I just want to say, because I'm talking to lawyers here and who are watching online, there are things you can do about this, things to support these public servants. Michelle mentioned the Election Official Legal Defense Network, which my organization runs. It's under the leadership of co-chairs Bob Bauer, former Obama White House counsel, and Ben Ginsberg, former counsel to the Mitt Romney and George W. Bush campaigns. And we recruit a network of thousands of lawyers all over the country who are willing to serve pro bono to advise and assist election officials in their official capacity. And I often think that while I'm proud to provide this service, I hope at some point it sunsets and we don't need to, because a nonprofit shouldn't need to provide this service in a free democratic nation like ours. And if anyone watching or in the room is interested in volunteering or learning more, go to EOLDN.org. That stands for Election Official Legal Defense Network.org, EOLDN.org. It's easy to volunteer. You click up one link and put in your information. And if we can use you, we'll let you know. We're getting up close to time, but I want to by the way, all these questions were great. We're not going to get to all of them. I want to ask a question about pre-processing of mail ballots, because this is one area in which Wisconsin is somewhat of an outlier. Virtually every state allows for mail ballots to be verified and pre-processed, not counted, but verified and pre-processed ahead of time, which allows for greater integrity because you can confirm the signature and make sure the information's all there. And if there's something missing, you can also reach out to the voter and ask them. Wisconsin, amongst battleground states, is somewhat unique, along with Pennsylvania, in not allowing that to start until Election Day, if I have that correct. Yeah. Do you have any thoughts, Lisa? I'm going to start with you, if that's okay, unless you want to defer. Would pre-processing be helpful?
Yes, I've been fighting for that for how many years?
We've been on that same.
I've been, Monday processing, just once again, not pushing the total button on the machine. I've been on this for 5, 6, 7 years or whatever, always get close. I always like to say to our legislators, April of 2020, we were told statewide, we had the election, but we were told statewide, do not push the total buttons. Nobody in my county did it. When the county clerks got together, it's like, okay, we're behind closed doors. Who had somebody push that total button statewide? Nobody did. we can do this. We can process these ballots on big elections so that we don't have the so-called ballot dump, but we just have to get it through and get people to trust this idea that we can process those absentee ballots and get rid of central count and do what we need to do to get those unofficial, remember, election night is unofficial results.
Either of you have anything to add on that?
Yeah, I worked with Lisa along with other legislators in getting at least a streamlined process for in-person absentee or Monday count. The legislature, I was more in favor of the in-person absentee process, and I think Lisa was more in favor of the Monday count. Anyway, we don't all agree on everything, but the legislature, the problem, the 2020 accusations, assertions, and there were problems. There were problems with 2020. Not all processes and procedures were followed correctly. There were a lot of problems, but that exacerbated the concerns that some legislators had in the entire electoral process. But we will get back to that spot, I think, with the legislators at some point to trust the process in order to go ahead with the Monday count.
Lindsay, you said.
I was just going to say, this is actually, I'm glad this came up because this was the point that I forgot earlier that I was going to make when we were talking about transparency. But I think this would go a long way toward just ensuring or helping with confidence in the legitimacy of the elections, because you won't have the appearance of that ballot dump at 8 p.m. when or after 8 p.m. when the 7 a.m. the next morning, then when you haven't stopped counting all night. But you won't have that increase because you'll have been able to find those errors the day before and work through all of that, and that'll go a long way toward and observers can be there for that part. So the transparency part is still there. So I think that would certainly go a long way. And we thought we were close last legislative session, and then the session ended and they didn't vote on it. So
yeah. I just want to end. We're at time, but the work of you all and your colleagues doesn't get enough notice, and but there are many of us in this room, including myself, who notice all the time, and honestly, it inspires me every day. I want to give the last word to Secretary Johnson, who dropped the note off up here. If it's with your permission, I'll read it out loud. He just said, "Thank you for your dedication to our democracy. You three are exemplars for the rest of us." And with that, can you thank the panel?
Sorry I was late.
So it was originally
Wow. There's another way you can help. There's a form in your packets. And if you are so inclined, because we are missing people who typically have done this, please take the time. A few years back, I signed up. I thought I was pretty knowledgeable and felt pretty comfortable with the integrity of the system. And I signed up to be a poll worker. And I went through the training. And I actually worked the polls, and we had a few instances where somebody with same-day registration and something happened, and the clockwork precision, and you noted it on the issue log, and two people went together to do, it was incredible, the care that went into it. I wasn't doubtful before, but I was rock solid at how hard these election officials work and how carefully they do their work to ensure that every vote counts. So if you are so inclined, when you're filling out your form, check the box and go work a poll. That brings us to our last panel of the day. We have Professor Chad Oldfather, a professor of law at Marquette University Law School, where his course includes both federal and state constitution law. His book, Judges, Judging and Judgment, Character, Wisdom, and Humility in a Polarized World will be published by Cambridge University Press later this year. And Professor Oldfather will moderate our final two presenters, and I will let him make the introduction, but I will invite up Professor Michael Wagner from the University of Wisconsin and George Stanley of Wisconsin Watch. Come on down.
I was a little worried I was going to be up here by myself there for a second. I'll just kick things off by sort of adopting by incorporation the thanks that have gone out throughout the day. This is obviously important work, and so thanks to everyone involved. Thanks to all of you for being here, whether you're here in person or online. Our panel is, of course, media and civil discourse. I think we've heard a lot of things this afternoon to leave us with confidence in how the system works. We've also heard, though, that large segments of the public don't feel that way. And so, there's this sort of transmission issue, I suppose, getting the information from the people like those of us inside this room who know how the process works and trust how it works out there into the world. A world without a Walter Cronkite to provide a single trusted voice. My role in this panel, I've got pretty much the easiest job of anyone who's been up here today, because I'm going to introduce these folks and then I'm going to sit back while they do their thing and then gather your questions at the end, and I'll get to channel those. So without further ado, our two panelists, we've got Professor Michael Wagner, who's the William T. Evju Distinguished Chair of the Wisconsin IDEA and Professor of Journalism and Mass Communication at the University of Wisconsin-Madison, where he directs the Center for Communication and Civic Renewal. His work explores how individual interactions in the information ecology affect what people believe, what they want, and what they do. He, among other things, serves as the associate editor of Public Opinion Quarterly, is the founding editor of the Forum in Political Communication, and a member of the General Social Surveys Board of Advisors, and has won a full handful of university-wide teaching awards. And then we have George Stanley, CEO of Wisconsin Watch, a collaborative nonprofit news outlet working to rebuild Wisconsin's local news ecosystem. He was editor of the Journal Sentinel since 2015, had been managing editor since 1997, stepped down in 2023 to lead the State of Local News project for Northwestern University. He has won a handful of, or had a hand in the winning of a handful of Pulitzer Prizes, and has participated in several national programs aimed at finding a sound future for local news, and among other things helped found the O'Brien Public Service Journalism Fellowship Program at Marquette University. So please join me in welcoming both of them.
Should I go first?
I believe you're up, right?
Yep. Okay, great. Hello, good to see you all. Thanks for having me here. I appreciate the invitation from Michelle and Lori. It's been a lot of fun thinking about things I can share with you, and then I'm really excited to hear questions from the panel and from you all as well. So I'm going to share with you data that's been collected by the team at the Center for Communication and Civic Renewal at UW-Madison, which I direct. And as even you can kind of see on the slide here, one theme of how the information ecology in Wisconsin operates is that the political right's communication ecology is more tight-knit and centralized as compared to the left's. And so here are each little circle is a person on Twitter in Wisconsin. And you can see the right's network is pretty well cordoned off and pretty tight-knit. The left's is more diffuse. You see some folks from the left excited to engage with some folks in the middle on the right, but you don't see as many of the red dots in the blue area as you see blue dots in the red. And so this is kind of a broad theme that kind of underlies a bit of what I'll talk about. So There we go. So I wanted to start by just showing you some evidence about the overall picture of where we stand as a country when it comes to our political divisions and our trust in information. And so in the upper left-hand corner is a figure from the Gallup organization that just measures whether people identify themselves as liberals, moderates, or conservatives. It starts in the early 1990s and goes through a couple of years ago. And basically the percentage of conservatives is flat at about 36%. The percentage of people who say they're independent has wavered a bit, but is at about that same level today. The percentage of folks who say they're liberal has gone from about 17 to 25%. So there's been an increase in folks who've been willing to call themselves liberal, and the other numbers have been flat for several decades. The bottom left is our trust in the mass media to report things that are right some of the time or most of the time, all of the time or none of the time. And you can see that in the 1970s, right around the time of the Watergate reporting, most notably coming from the Washington Post, but several other outlets as well, trust was quite high in the 70% for the American news media, and that has dropped precipitously low into the 20s in more recent years. And so the trust in our information has cratered over the last 5 decades. And then the kind of peculiar looking figure on the right is the distance between the average Republican and the average Democrat for most of American history, or the average right party and the average left party, depending upon earlier years with Federalists and Anti-Federalists and Whigs. And but red for the more conservative of the parties, blue for the more liberal, and you can see that the division between the average voting member of our federal government is wider now than it's been at any point in our history, including right before and during the Civil War, when we were literally killing each other. And so our lawmakers are as different from each other as they've ever been. Our trust in information is at its lowest point in 50 years, but how we see ourselves politically has been relatively flat over that same amount of time. So what's going on? One thing that's happening is that we trust information differentially. We trust information in a partisan way, which we did not used to do. And so at the very, very bottom, you see most Wisconsinites trust local television news the most. In fact, it's the most trusted source for all groups, with the exception of Wisconsin Republicans trust Fox News slightly more than they trust their local TV news station, but it's almost the same, 55% to 53%. But otherwise, groups trust local TV news the most, then local newspapers, then national legacy papers like the Wall Street Journal and the New York Times, and then you start to see pretty big partisan differences, with well over half of Democrats trusting MSNBC, well over half of Republicans trusting Fox, but not the same thing happening in the other major political parties. And so big differences in terms of overall trust in news based upon the source of information. Oop, this thing is really sensitive. Okay, where do Wisconsinites get their information? Conservatives are more likely than anybody else in Wisconsin to get their information from talk radio, especially conservative talk radio. This has slightly started to change since the advent of Civic Media, a company that's been buying up radio stations around Wisconsin and programming them with kind of center-left programming over the last year or so. And so that's slightly been changing, but conservative talk radio is still quite dominant for Wisconsin. Local newspaper readership is done the most by Democrats, then by Republicans. Independents do it the least amount. One thing that I think is important to think about as well is that still number one is local television news. We talk about social media, we talk about the internet, we talk about digital news. Local TV news is still the most consumed and the most trusted source of information. It also covers very little political information. And so our top and trusted source doesn't do a whole lot in terms of covering political information in our state. Using a tool called Critical Mentions, which allows us to search keywords that appear on air in local television news outlets in markets across the country, including Wisconsin. We looked up how many times legal experts or plaintiffs or defendants in cases related to redistricting in Wisconsin, Act 10 in Wisconsin, abortion in Wisconsin, election law, the 2020 election, how often they were quoted on local television news. And it was in the single percents, even in stories about those issues. And so expertise is not getting covered by our most popular news sources. Of course, this is just trust. What do people actually use, and how do they organize themselves? And of course, we don't just use news. We also can engage in political conversations with others. We can use social media to get information. And what's interesting is that one of the largest groups is the group that gets minimal to little to none news. So people who avoid news are a pretty large group in Wisconsin. And it's bipartisan, right? About 36% of Republicans fall into that category. About 39% of Democrats fall into that category. Of those who use traditional sources only, so local TV, local newspaper, national newspaper, network television news, that's ABC, NBC, CBS, just the traditional sources that were the ones available when most of you were growing up. That's used by about 46% of Wisconsin Democrats, about a quarter of Wisconsin Republicans, a little more than 40% of Wisconsin independents. Traditional news plus more Republican-leaning news, so some of those traditional sources plus Fox News, Breitbart, One American News Network, conservative talk radio, about 1 in 5 Republicans in Wisconsin have that as their media diet. In terms of only getting news from Republican sources, about 15% of Wisconsin Republicans do that. There were no Democrats in our surveys of Wisconsinites who just got their news from Democrat-only sources. So that would be just MSNBC, Huffington Post, liberal talk radio, and not any traditional news or not any other kinds of news. And then, so you can see that a lot of these are pretty small. Another way to think about this, I'll talk about in just a second, but of course news isn't the only place we get information. We also talk to people about politics. One thing that we found in our work from 2018 to 2024 is that the percentage of Wisconsinites who say they've stopped talking to a friend about politics because of political disagreements has gone from 33% around the time of Act 10 in 2010 to more than 50%, almost 60% in 2024. And the percentage of Wisconsinites who've cut somebody out of their lives, so not just stop talking politics, but they'll talk the Badgers or the Packers or the weather or fishing or beer or cheese or something. The folks who just say, you're out of our lives, that's 1 in 5 Wisconsinites have done that. They've cut somebody out of their lives over political disagreements. So who are we talking to? We tend to be talking to those who are most like ourselves. Republicans talk to Republicans the most. Democrats talk to Democrats the most. Independents talk to independents the most about politics. And there's not all that much political crosstalk reported in our surveys of Wisconsinites. And these are surveys done of 1,000 to 3,000 Wisconsinites in a repeated fashion over the course of election cycles in 2018, 2022, and we'll do it again in 2024. If we bring this all together, so the news you get, the humans you talk to, and the social media you use and how you engage in it, there are basically 4 political communication repertoires in Wisconsin, the largest of which are people who avoid information altogether. They do less than average on everything. Broadcast TV news, social media news, liberal cable, liberal newspaper, conservative broadcast, conservative online, talking to family and friends, talking to coworkers, talking to Republicans, talking to Democrats, and expressing themselves on social media. Avoiders do that less than average across the board. Those in the conservative political communication repertoire are using conservative broadcast the most. They use a little bit of conservative online news. They talk to Republicans. They talk to their coworkers, sometimes who are different than they are politically, and they express themselves in social media. Almost the converse of that is the liberal communication repertoire. They're like conservatives in that they also talk to coworkers and also express themselves in social media, but they don't use conservative sources. They use more left-leaning sources. And then the smallest group are the omnivores. They do it all. They talk to anybody. They'll read anything. They'll watch anything. They'll listen to anybody. And it turns out that that group is the most trusting. They have the highest support for equal participation. They have the highest support for majority rule. They have the strongest trust in our election results, and they are the smallest group by far of people in our state. Those folks who are living in those bubbles, the far right or more far left political communication echo chambers, the conservative repertoire, the liberal repertoire, also have more extreme views than people in their party who don't live in those bubbles. The biggest differences are in terms of supporting the Black Lives Matter movement. So Democrats in more liberal echo chambers, more supportive of Black Lives Matter than other Democrats. Republicans living in those same echo chambers, less supportive of Black Lives Matter than other Republicans who don't live in those echo chambers. Same for abortion. The echo chamber Democrats, more pro-choice. The Republican echo chamber Republicans, less pro-choice or more pro-life, depending upon your point of view. Other issues, there's less of a difference, like taxes. The echo chamber doesn't really drive differences very much, say, in people's support of taxes or of healthcare, especially for Democrats. The echo chamber Republicans are a little less supportive of the Affordable Care Act than non-echo chamber Republicans. This also, interestingly, has some connections to the rural-urban divide in Wisconsin. Urban Wisconsinites report far more satisfaction with healthcare, with high-speed internet access, those kinds of things, whereas rural Wisconsinites report way less satisfaction with access to healthcare and high-speed internet access, but report greater satisfaction with public safety. Urban Wisconsinites report less satisfaction with public safety. So some of these differences are also geographic. How does all this relate to different kinds of issues related to elections, especially related to issues of the last panel? On the one hand, one takeaway is that Republicans, Independents, and Democrats are at least somewhat confident that their vote was counted in 2020 and again in 2022. Strong majorities, well over 50%, are at least in the somewhat confident category. But notable partisan differences, Democrats are way more likely to be in the completely confident category that their vote was counted, whereas Independents and Republicans waver between somewhat and complete confidence that their vote was counted in Wisconsin in the last couple of elections. These representations and how our information diets also affect our attitudes about our confidence in election results. And so you're looking at interviewing the same Wisconsinites at 3 points in time, right before the election, after the election was called, and a few months later, in March of 2021. And one thing that we note is that the further to the right you go in each of these figures, the more a person's media diet is in the conservative media echo chamber. The further to the left, the more in the liberal echo chamber, and a zero contains both the omnivores and the people who kind of avoid information altogether. And the extremes are more the extreme left and right. The blue line are Biden supporters, the red line are Trump supporters, and the dots are where each individual of the 3,000 people we interviewed arrayed across the surveys. And of course, we lost some people over the time, and not everybody who took the first survey took the last one. One thing that we note is that the more that people were living in a more right-wing media echo chamber, the less confidence they had in election results. It especially cratered for those in the most extreme part of the echo chamber, and it especially happened in late December 2020. After the events of January 6th, you can see that bounced all the way back up to almost equal confidence that folks on the left had in election results. And so there was this time when there were lots of public commentary from the former president and others that the election was rigged and unfair, and there were these attacks that you just heard about on election administrative folks. Confidence amongst Republicans in Wisconsin plummeted, especially for those who lived in a more right-leaning media environment, and that after the events of January 6th, that came back up to levels that were consistent with other Wisconsinites. Same kind of thing happened in terms of different democratic values related to majority rule, equality, or political equality for folks who lose elections, and the ability to participate. One thing that's kind of interesting here is that Trump supporters in the most right-wing news flow became the most supportive of minority participation rights after Trump lost the election. So once out of power, became more supportive of participation rights, which is the exact opposite of the exact opposite thing happened in 2016. Democrats became more supportive in just the same way when the Obama administration ended and then was replaced by a Republican administration. So some of these things happen regardless of who's in charge. Just like if you ever have seen Charles Franklin from the Marquette Law Poll talk about is the economy going in the right direction? And you ask in October, and then you ask in December, and if the party of the governor changes, the party of the president changes, partisans immediately, the economy that sucked seconds ago is now amazing. That kind of thing happens, and it's kind of a partisan way of viewing the world. So what sorts of things, I was asked to talk a bit about things we can do to break out of echo chambers. It seems like the kinds of media sources that people use, the media diets people have that are associated with trusting in the vote count, thinking that the people should have a say in rule, and supporting the idea of compromise. It seems as though a traditional plus democratic news constellation, or traditional only, are the most associated with supporting those attitudes. But these are all done in environments when Trump was president, and so it could be that those might change a bit as we measure them again now that Biden is president. And then looking at different sources and trust in the vote, so local TV news, national public radio, local newspapers, national newspapers, these are the sources that are most associated with support for trusting the vote count, trusting that the people should rule, and supporting a political compromise. It's also worth noting, just as the last panel was finishing up, we'd also done a lot of research asking people questions about their equal access to the franchise and able to vote, and we found Hispanic Wisconsinites in 2018, 20, and 22 reported triple the time waiting in line to vote as compared to other Wisconsinites, and Black Wisconsinites reported double the time it takes to get to the polls as compared to other Wisconsinites, and those now results have held up across 3 elections. Wisconsin Watch has actually reported some of that data in some of their stories about the election. So we've done some work about access to the polls, and then we've asked people who didn't vote, why didn't you vote? And it was the lack of the right ID tended to be the top answer for those who tried to vote on election day. And of course, in Wisconsin, voter turnout's already way higher than it is almost anywhere else because of same-day registration and the state's long history of participation. Last couple quick things about what else breaks out of an echo chamber: diversity of conversation, diversity of information source. And so here, as we move from the left to the right in each of these figures, we're going from my information network is not at all or is extremely diverse on the left to not at all diverse on the right. So in other words, people who live in a left-only Polcom repertoire or right-only Polcom repertoire are in the far right of each of these figures. And we're looking at the likelihood that they'll split their ticket when they vote. People who have a diverse network of talking to people, this is the figure on the left, have about a 25% chance of splitting their ticket. People who have a diverse use of news have about a 50% chance of splitting their ticket. People who only talk to folks like them, literally touching 0. People who only look at news from their side, it's literally touching 0. So these folks don't split their ticket. So elections are won and lost by this very small group of people who have a really diverse network of people they talk to and a really diverse set of information that they get. Support for compromise is strong in Wisconsin. I think it's just important to point this out. We live in this polarized country, but everybody says on both sides we should compromise and get something done. But breaking out of these echo chambers is no easy task. When we ask people, how diverse is your information use? They say, oh, well, I'm very balanced in the information I get. They say, what about people in your political party? They say, well, they're not as balanced as me, but they're still pretty balanced. That's the middle dot, right? So self right in the middle on a 5-point scale. Look at me, so right at the 3, beautifully balanced. People in my party, they're not, they're a little more, for the home team. What about people in the other group? Oh, no, those folks, they just get information from the other side. And Republicans and Democrats say that about the other side in equal measure. And so we think the other side's bubble is filtered, which makes it difficult to talk to people who are different than others. And so what these figures are basically showing you is that when we think the other side won't pay attention to us, we choose not to talk to them. So we've decided to close off conversation before having the conversation, which makes it very difficult to build the trust that we have to build in election administration and the trust in our vote count and other kinds of things to make democracy work. To have the minimal bar to make democracy work, which is that we think we counted the votes accurately and the person who got the most votes ends up in the office. So I'll stop there. Thank you so much.
Thank you. That was great. Can you hear me okay? Okay. And that's the way it is. That's how Walter Cronkite used to end his newscasts, with that very confident statement, because he was delivering the facts of what happened that day. And that's back when that trusted news was way up here. Starting with the advent of 24-hour cable, which led to 24-hour news, which led to 24-hour opinion, which is much cheaper to produce than news. We've continued to spawn more niche markets. Walter Cronkite was trying to serve the entire United States and had 100 million viewers. These niche markets that developed are going after marketplaces, and they developed new niche marketplaces, and many of those marketplaces are opinion marketplaces. And it's also, that just got compounded. Talk radio borrowed it from cable, moved to the internet, which just compounded it. But if you could see in that chart, the trust actually started to drop before the people were widely using the internet, because of what was happening with cable and talk radio borrowing the same business model as cable was using. There's a good book on this that discusses this history for those of you who are interested in reading more. It's called Truth Counts, A Practical Guide for News Consumers. And in one chapter, my friend Tom Rosenstiel writes that we've reached a moment in the shift from verified, fact-based news reporting to the type of emotional things that make people angry, and that's what makes them most likely to share on social networks, and that's what drives the business of the social networks. We've moved so much in that direction that perhaps most menacing, he writes, the techniques of denying facts, demonizing the press and the academy, and the idea that people should believe their leaders rather than mediating institutions are the proven tools of despots, tyrants, and dictators. America rose in defiance of tyranny. To find a way forward, we need to get back to our roots. As our nation's founders were voting on the new Constitution in 1787, Ben Franklin was famously asked, "What have we got, a republic or a monarchy?" "A republic," he said, "if you can keep it." The colonies had won a war against the world's most powerful military to gain freedom from a king and give birth to history's first democratic nation. They were students of history, and they understood how tyrants gain and maintain power by controlling the stories delivered to the people they dominate. That's why the First Amendment of our Constitution protects the rights of a free and independent press. Our founders knew the American people needed to be informed by other citizens who were not in power in order to understand what was really going on, in order to hold their elected representatives accountable, to fight lies with truth, and to sustain the earth's first nation of the people, for the people, and by the people. They did more than establish this press freedom in our Constitution. They actually subsidized it. King George had used his postal service to try and control the flow of news and information in the colonies by banning, dumping, and destroying newsletters and newspapers. Our first Congress worried about that, and they also worried about how people outside the big cities of Boston, New York, and Philadelphia were going to get enough news to guide their local communities and elect capable representatives. So America's first Postal Act, signed into law by George Washington, provided free delivery of newspapers as a public service. This helped sow the seeds of a local news industry that expanded to serve a free and growing population. Local commerce soon did the rest, from people selling to their neighbors through classified ad sections to local retailers and services advertising their wares. This local commerce business model supported news reporters who covered police and fires, zoning and planning commissions, school boards, village councils, county boards, and community events from our smallest towns to our biggest cities for more than 200 years. But a lot has changed in the last 2 decades. We've lost 6 out of every 10 journalists in Wisconsin and nationwide. An average of 2 local newspapers close every week. Hundreds of daily newspapers have been purchased by cost-cutting national chains, milking their declining cash flow. Huge swaths of America have little or no local news coverage today, and it's getting worse every year. This threatens the health of our republic. So how did we get here? A huge chunk of the revenue that paid for news reporting over the years came from people reaching out to their geographic neighbors. Businesses posting job openings, rummage sales, folks looking to find new homes for old cars. These were gathered together under the group headings under classified ads. They filled sections of local newspapers, delivered to nearly every household in nearly every community. The other primary source of revenue supporting news coverage came from local retailers, grocery stores, clothing stores, hardware stores, car dealers, theaters, all advertising products, sales, and services to households within driving distance. The income from that local commerce covered all costs of news coverage, from the 2 reporter staff at the Lake Geneva Regional News, where I started in 1979, to newsrooms of 60 or 70 journalists in cities like Green Bay and Appleton, to more than 400 journalists in cities like Milwaukee, to more than 1,000 journalists at the biggest competing news organizations in New York, Chicago, and Los Angeles. Reporters were there, covering the public's business, and the news business did not need donations. In the last year of the 20th century, I was managing editor of the employee-owned Journal Sentinel, its corporate headquarters at 4th and State. The company and its newspaper set new records that year for revenue and profits. 40% of the Journal Sentinel's income and a higher percentage of its profits came from classified ads. The paper's top 3 retail advertisers that year were, in order, Boston Store, American TV, and Circuit City. Then the 21st century arrived with Y2K, and a lot of people were worried our computers were going to make everything stop working. But the true threats often show up stealthily. In 1999, Craigslist was a startup largely unknown outside of the San Francisco Bay Area. It provided free classified ads to people venturing onto the World Wide Web. Founder Craig Newmart supported his small staff by selling display web advertisements next to the classified ads that people were posting for free. Craigslist and other free online classified services spread like windswept wildfires across the nation, first to the big cities and then to the small towns. Classified ads disappeared from local newspapers. In 10 years, these free digital services had extracted nearly all the classified revenue from every daily newspaper in America. That meant costs had to come down at every newspaper in America, and newsrooms shrank, along with press rooms, marketing departments, customer service teams. You notice the customer service, I know, and advertising sales staffs. Of course, new information technologies were changing far more than the way people sold used cars to one another. Folks started buying books they couldn't find in local stores from a Seattle-based startup called Amazon. Not ebooks. The Kindle wasn't invented yet. Books with hard covers and paper pages. That is all Amazon sold in the late 1990s. That's all they sold. Next came Google. Remember when someone first showed you their magic "I'm feeling lucky" search button? Then there's the iPhone. That came in 2007. A supercomputer with tremendous search power in our hands. This machine not only helped us find just about anything we might be looking for, but tracked our search words and where we happen to be standing at the moment. Ads powered by that information were sold to anyone who wanted to make us an offer right now. Local retailers saw sales begin to plummet. And then came the Great Recession of 2008. Circuit City, a consumer electronics pioneer, went out of business in 2009. When American TV closed shop in 2014, its family owners explained that their showrooms had become their stores had become showrooms for Amazon, just 14 years after they were only selling books. Folks would come into a store, find a product they liked, search on their phone to see if someone anywhere in the world was selling it cheaper than that, and with a few taps have it delivered right to their door. After first buying other chains and then being bought, Boston Store died in 2018, ending a 120-year run as a Milwaukee institution and as the anchor advertiser of local news outlets. By that time, the Journal Sentinel, owned and operated in Milwaukee since before Wisconsin became a state, had been sold to a chain based in Cincinnati, then sold 1 year later to a chain based in Washington, D.C., which itself would be bought by another chain in 2019. The Journal-Sentinel is one of hundreds of daily newspapers owned by Gannett, as are the Green Bay Press-Gazette, Appleton Post-Crescent, and 8 other Wisconsin daily newspapers. Last I looked, the total market value for all of Gannett's hundreds of local news businesses was worth just 40% of $1 billion offer made to buy Milwaukee's Little Journal Communications in the late 1990s, an offer that was rejected as too low. And I don't mean to suggest this is anyone's fault. People invented new technologies to provide lower services and more convenient, lower prices and more convenient services. They could not have foreseen all the unintended consequences. The freedom provided by our democracy spawns innovation and the sharing of ideas and information. That has brought enormous good into our world, but not without a cost. Since 2005, 3,000 newspapers have gone out of business in America. About half our nation's counties only have one news outlet left. Hundreds have none. The smaller and less wealthy the community is, the bigger the impact, which explains why so much of our remaining reporting is national news from our largest cities. All of Wisconsin's daily newspapers are owned by distant cost-cutting chains. They were all virtually, except 2, locally owned when I got out of Madison's journalism school. All of our TV stations are owned by national chains and most of our radio stations. In the past decade, even many of our community weekly news outlets have been sold to faraway chains. At the same time, our state has become one of a half dozen key swing states in the presidential electoral college race. As a result, we attract huge flows of attack ads and misleading propaganda from those seeking power and influence. Partisan websites that mimic independent, nonpartisan news outlets have proliferated. Opinion talk show hosts have replaced radio news staffs. Our state and local politics increasingly reflect the bitter us-against-them dysfunction that we see at the national level. National groups are even promoting candidates in races for suburban school boards often not covered anymore by reporters because there are not enough of them left. This all contributes to the fracturing of our communities and to declining trust that we can actually find effective solutions to vexing problems, as your chart showed. One example, as the 2022 election year heated up, national forces of us-against-them propaganda seized an opportunity to stoke anger and passion in Kiel, Wisconsin. Sarah Beth Berman, leader of the American Journalism Project, mentioned Kiel and how Wisconsin Watch's truthful reporting helped the community regain its equilibrium in a national speech last December. And I'm going to see if I can figure out how to play this for you. The big button?
Good afternoon.
Oh, sorry. It's really good.
I want to tell you about a community in northeastern Wisconsin called Kiel.
Give it a little more time and then I'll give up.
Population 4,000. Its claim to fame, it was once the wooden shoe capital of Wisconsin. But last year, like so many communities across this country, Kiel found itself divided. A debate on the school board about race and gender had become so heated, the town was nearly immobilized. Bomb threats closed the schools. Graduation ceremonies were postponed. The Memorial Day parade was canceled. And worse, people couldn't figure out how they'd found themselves in this moment. They said they didn't recognize one another. But then something extraordinary happened. Journalists at a nonprofit newsroom called Wisconsin Watch discovered that much of the information that was fueling the conflict was part of a misinformation campaign that was being fomented by forces outside of Kiel. And when Wisconsin Watch began reporting, the heat started to subside. One resident said, "Your reporting without a doubt helped save our community by allowing the citizens of Kiel, armed with the truth, to pull away from the grips of a small fringe group." You may have heard local news is dying. I'm here to tell you it's not.
So that was that. Actually, the reporter she mentioned that did that report on Kiel, Mario Coran, has led the reporting this year on the lockdowns in the state prisons and the health problems causing that led to that shocking arrest of the warden at Waupun and 8 other workers at Waupun, almost like it was a Shawshank Redemption coming to life. Same reporter. High school graduation canceled. Memorial Day, honoring the veterans who died for our country, canceled. This is what it means to democracy and community life when we no longer have trustworthy, independent sources of news and information. To keep our republic, we must rebuild our local news ecosystem in places like Kiel. So what can we do about it? Given the huge loss of reporters covering local government and community life, we need to begin by nurturing collaborative efforts where newsrooms work together to gather the resources necessary to tell the stories that matter most. We need to use every reporter we've still got and build from there. As a locally owned nonprofit with a mission of providing impactful reporting and sharing it freely, Wisconsin Watch is the only news outlet in a position to build this network across our state, but you can help. Here's a quick sampling of what we hope to do with help from members, donors, and everyone who cares about rejuvenating democracy and civic life in Wisconsin. Our State House Bureau, launched in 2022, provides evidence-based reporting and fact-checking to more than 200 news outlets across the state and the Associated Press. We're not duplicating what other reporters are doing, but instead providing audiences across the state with key accountability and investigative stories that otherwise would not be reported. We hope to add enough reporting staff to offer our services as an in-depth reporting team for all newsrooms in the state that no longer have the resources to dig deep. If a local news outlet or citizen suspects incompetence, wrongdoing, corruption, bad practices, they can bring it to Wisconsin Watch. We'll recruit the skills needed to tell these stories and inform the public to the best of our ability. We'll also search for examples of places doing a better job for real-world solutions and share these stories freely. This helps provide a roadmap to use when taking on big challenges. We're taking our fact checks, our political and government reporting, and highlights from our investigations and converting them into short audio and video reports. The goal is to reach and serve folks who aren't getting accurate, fact-based local news today. The radio reports will be offered freely to both commercial and public radio stations, reaching folks in small towns and rural areas with low broadband access. Barely any of these stations offer any local news today, though many carry syndicated opinion shows. In addition to the radio reports, we'll produce video summaries to reach young adults who primarily get their news through video shared on Instagram, TikTok, and YouTube. We're building up local news bureaus to fill news deserts and reporting gaps, starting with Green Bay and Milwaukee. In Green Bay, we're building upon a 3-year Northeastern Wisconsin News Lab initiative that includes the Press Gazette, Post Crescent, Green Bay Press Times, Fox Valley 365, and Wisconsin Public Radio. In Milwaukee, we're building upon long-standing partnerships with Neighborhood News Service, which we've just become one organization, and other local news outlets. We're listening to the communities to learn their most pressing information needs. Then we'll find ways to fill them. And interestingly, one of those is just telling people what they need to bring to the polls to vote and to make sure they can vote. And also, this year, because people are being trained to challenge votes at the polls, how to deal with that if your vote is challenged at the polls. The focus of our beats will be public service, challenges people are facing, solutions folks are bringing to the table, key issues such as education, skills needed for unfilled jobs and how to get them, affordable child and senior care, the challenge of today's housing market. And once we're up and running in Green Bay and Milwaukee, we aim to replicate this across the state. Our democratic way of life is at greater risk today than I would have thought possible at the start of the century. 200 years ago, French political reporter Alexis de Tocqueville set out to describe to his peers in Europe how America's experiment in democracy was working. He witnessed how it often wasn't pretty, and I agree with Kathy Bernier on this, and I agree she's been a hero, by the way, but I agree with her on this, that there's reason for optimism. This has been messy for a really long time. It was messy, difficult, and included all kinds of people, characters, and ways of looking at the world. When someone tried to describe the United States as enlightened, Tocqueville stepped back a little bit. And he said, the greatness of America lies not in being more enlightened than other nations, but rather in her ability to repair her faults. Corruption, incompetence, and other injustices come to light in our country because people of goodwill become aware of it, want it to stop, and bring it to the public's attention. Without calls for action from informed citizens who can hire and fire their government leaders, problems do not get fixed. Corruption gets rewarded. Honest people get punished for trying to do the right thing. When this happens over long enough time, people learn it's fruitless and even dangerous to try to fix things, and they stop trying. Welcome to Russia. So, a concerned government employee, after being stifled by superiors, finds a reporter and describes troubling signs of massive fraud in the state's subsidized child care system. Or an agency department head follows a reporter into a hallway during a public meeting break to share keywords a person might want to include in a Freedom of Information Act request. Or a courthouse clerk delivers 2 files to a reporter who only requested 1. These are all real examples. One recent December, a Wisconsin reporter was ringing a Salvation Army bell as a Christmas volunteer and received a donation of key video evidence revealing how political interference had sidelined a police investigation into a wealthy campaign donor accused of drugging and raping a woman. Representatives of the public must be present for these things to come to light. Perhaps the most rewarding story I've worked on in 45 years started with a phone call to a health reporter from a furious ER doctor who respected the reporter's work. The doctor had just saved the life of a 5-day-old baby who had been flown by emergency helicopter from a small town in central Wisconsin to Children's Hospital in Milwaukee. The medical literature said the baby was past saving, the ammonia levels in his blood were too high, but the doctor had to try. Now he feared the baby, though alive, might have permanent brain damage. Healthy at birth, the boy had inherited a rare genetic condition that should not have been life-threatening if diagnosed within 4 days. Every newborn in America has their heel pricked for a blood screening test shortly after birth to detect this and other potentially deadly genetic conditions. The tests are supposed to be sent within 48 hours to the state newborn screening laboratory for diagnosis. If that had happened, this baby could have been treated with sugar water and sent home from the hospital in good health. They're batching, the doctor shouted to the reporter. They're doing it all over the place. They won't listen to us. You've got to stop it. Our investigation found that hospitals across the nation were holding on to newborn screening samples, sometimes for days, before shipping a batch of them together to the state lab to save a little bit of money on overnight shipping or courier transportation costs, or simply because they were sloppy. On top of that, some states shut down their screening labs on Saturdays, Sundays, and for 3 days in a row on holiday weekends. So as our reporters discovered, a baby born with one of these conditions on a Tuesday in Colorado was a healthy toddler. Another baby born in the same state with the exact same condition on a Friday before a holiday was being visited by his grieving parents in a cemetery. Our reporters also found that one state, Iowa, was doing newborn screening right. Iowa's director of newborn screening made sure every test from every hospital was delivered to the state lab in time to meet all medical standards, so that each deadly genetic condition would be spotted within the crucial 4-day window. Iowa also found that health insurance companies readily paid the $50 or so it costs to get the tests in on time. Iowa's a big state, Some hospitals are hundreds of miles away from the state lab. So when the other states and hospital systems made excuses about budgets and logistics and how it was far more difficult than we realized to meet that 4-day standard, our reporters responded, "Iowa does it." The excuses evaporated. We built interactive databases so people could look up newborn screening results from individual hospitals in 36 states where we could get data. We shared our reporting freely with anyone in the country who wanted to publish or post it. The landscape changed nationwide almost overnight. When little Juniper Horrock's life was saved at rural Utah, the same week the state launched a new FedEx screening delivery system, state health officials publicly thanked our reporters. This is how America repairs her faults. And this story could have come to any news outlet in America except one in Iowa. However, today, the health reporter who received that doctor's call works in Washington, D.C. for the Post. The investigative reporter who collected and mined the information, built the interactives, wrote the lead story, and found the Iowa exception works in New York City for the Times. The reporter who uncovered the Colorado infant deaths caused by a state lab being closed for 3 days in a row accepted a cost-cutting buyout and retired. We need to rebuild our local news ecosystem so we can handle the next story like this that rises from a small town in Wisconsin. You can help. We need to hire more reporters. We need to act now during this election year to defend our republic. Thank you.
We have a few minutes for questions. I have one, which I think, falls under the general category of what else can we do? And this is, should the fairness doctrine be reinstituted? And if so, what impact would that have? Do you want to go first?
Sure. That's a good question. I know. This question gets asked a lot at forums like these. So first of all, the likelihood of that is near zero. If it happened, the questions would be, well, for whom would it apply? Would it be would social media companies be required to police this in some kind of way? Would it just be radio? Would it be television? What about cable television? That's not the public airwaves in the way that NBC, ABC, and radio stations are. And so it's difficult to know how it would be policed. But if so, it would do the good work of providing multiple perspectives on issues. Right now, lots of more ideologically oriented sources will seek out people from the other side to appear, and often the best advocates don't want to appear on places they don't think are trustworthy sources of information, or the ideological sources will pick, the B squad from the other side to have them articulate that position. And so the fairness doctrine might be able to result in a more even-handed sharing of ideas, but I don't think that's probably not a good use of our time, because it's not at all likely to come back.
So the fairness doctrine came about because of the public airwaves, as regulation of the public's airwaves. And so the government felt it could regulate the public airwaves by saying, if you have a license for a radio or TV station, you have to present both sides of political questions. That's why we didn't have talk radio before the fairness doctrine was booted. It was booted because of cable. So cable changed the world. They didn't have licenses. They weren't the public airwaves, and they were able to do all sorts of stuff. And then the networks said, "Hey, you're tying our hands. How can we compete with these guys with all these laws that we have to follow and they don't have to follow?" So that's why they got rid of 3 laws, actually, and fairness doctrine being a key one. Another one was they made it much harder to protest license renewals. And the same week, I believe, I might be wrong on that, but very close in time, that they changed the licensing of radio stations was when WTMJ fired its entire news staff, virtually almost its entire news staff, because opinion is so much cheaper. One person spouting opinions and not doing any reporting whatsoever is a lot cheaper than having reporters go cover stuff.
When I was working in radio news, I was hired at the largest station in Nebraska a 50,000 watt station. The day I was hired, it was locally owned. The day I started, it was owned by a company called AM/FM. And the day I resigned was when it was bought by Clear Channel. And they were saying, you'll be the last, we'll fire all the other reporters, you can stay and you can just read the AP. And I said, well, that's not reporting, so I'm not going to do it.
It is local reporting. We've got one other question. It begins as follows. Some countries have less tolerance for fake news or libel slander than our country, where some opine that the First Amendment protects the, quote, right to lie. What do you think about efforts to limit fake news and the spread of misinformation? In your opinion, would or could efforts to suppress misinformation help or harm our free press? There's a big double standard, again, legally, and this is real interesting legal questions, between publishers and the internet. So publishers are liable and can be sued for slander. It's a high threshold, but they can be sued. It's not nearly as easy as in England, where they're trying to protect the royal family and things. But you can be sued and you have to defend yourself. In the internet, Facebook, they can't be sued for anything, no matter what gets posted on our things. So it's a really interesting question that I don't think people have figured out yet.
And I also would say that it's not at all clear that the government would support that idea. So, for example, I have a grant from the National Science Foundation, and the grant is predicated upon trying to identify networks of misinformation and then peppering those networks with things that are true. So not pulling down anybody's post, not asking Twitter or Facebook to say, pull down this thing that's not true, but just show the people who saw the thing that wasn't true something that is. That's our project. And the Weaponization of Government Subcommittee has subpoenaed me, has FOIA'd us, has done all kinds of things. This is from our own government saying, why is it that you're colluding with the federal government to suppress, speech on one political side or another? So I don't know that there's a path where the government might be involved that we would want to trust. Thinking back to the previous panel, we're not getting as many public records requests as they're getting, but I've gotten 7 in the last year, and there's no staff. It's just me. Instead of preparing lectures and doing research, I'm just searching emails to see if they're germane to these kind of bizarre requests that happen all the time. And so these kinds of things happen, and it's all in response to studying misinformation. And of course, there's lots of big questions about who decides what's true. Some things that are true on Monday end up not being true the more we learn about them later. And so, journalists have to cover both of those things. We thought this was true, and then we learned something else was true. Journalists publish corrections. Social media posters and ideological outlets don't. And so it would be great if there was some sort of mechanism to help tamp that down, but freedom of speech makes it difficult to regulate that, I think. Yeah.
And with that, we will bring it to a close, and thank you once again for a fascinating discussion.
My name is John Skilton. I think significant is the fact that I've retired as a practicing law lawyer after 54 years. It doesn't necessarily mean I'm free to speak my mind. But regardless of that, the panelists that just spoke were remarkably informative and frankly a little depressing in some, which leads me to the question of whether the bottom line of the tremendous effort that's being put on the ABA and the task force is something like this too shall pass. But it ought not be. And when we look at the pieces so carefully, it seems to me we are in danger of losing sight of the goal. On a personal note, I was born 6 weeks before D-Day. the first president I perceived as a thinking youngster was Dwight Eisenhower. My generation saw the Vietnam War, which tore us apart, 3 assassinations. This is when I'm in college. And we began to have a sense of not seeing the whole picture from our leaders, and in fact having that picture on occasion distorted. And to some extent it continued to the point where one had to wonder whether our system was working correctly, which I think takes us right to today. I think what I had that made me most proud as a lawyer and the volunteer work that I've done was having been chair of the Lincoln Bicentennial Commission for Wisconsin. And through all of the misery and grief, as we hear these appalling statistics on faith and confidence in government, there was no period in this country worse than the Civil War. It killed 600,000 people. And it, I think, gave this country every challenge of staying together that any country could ever have, including, obviously, the violence of the Civil War. I was in Washington the day after the terrible bombing of the Trade Center and had the occasion to walk the mall. It was pitch black. The lights were out. But I had walked that mall many times before, and one of the plaques, somewhat buried in the mall, is the plaque of the founders who signed the Declaration of Independence at the risk of death. I believe the number, and I'm not absolutely sure, is something like 20 of those signers were lawyers. And that really, I think, charged my belief that lawyers have something to say about what happens in this country. They were there in the beginning, and Abraham Lincoln was a lawyer. And I mention Lincoln because that same night that I walked through a dark mall, I walked up the steps of the Lincoln Memorial and found myself alone with one person, that is the guard, and dim lights on 2 wonderfully inscribed walls, one with the Gettysburg Address and the other with the Second Inaugural. The words are eloquent, but the thought is even better. The role of government and of lawyers in a time of crisis is not to divide, but to heal the wounds if we can, to bring it together where possible, and not take revenge. These solutions, whatever they are hard to reach. I don't know how in the world any one group can solve the problem, but we could certainly start the process and try to make a difference. And that, I believe, is what the task force is all about. It is not to divide. It is to try to teach what is so fundamental in our government, and that is freedom, freedom to speak, freedom to pursue happiness, however defined. And so I hope that the invitation that this task force gives to participate is one that you take seriously, because frankly we need everybody in this room and all lawyers to be fully engaged in the preservation of what we all know to be the most superior form of government available to man. And to borrow from Franklin, that it's not to be lost. The logo of our little commission is on the wall, on the screen. The half sun logo was literally filmed from Washington's chair at the time that the Declaration was signed. And that's the one that, I'm sorry, the Constitution, 87, that I'm talking about, 1787. That's the one that has the sun. And the question raised by Franklin was whether it was half setting or half rising. And after hearing the debates and reading the document, he concluded that it must be half rising. And I can believe with all my heart, after 54 years, it hasn't yet fully risen, but it will. So we thank you very much for your contributions and for your attention, and particularly to the wonderful speakers who have given really information, but more than that, a challenge. Thank you.
Well, it's my opportunity to say thank you for spending a half a day with us, looking at the issues affecting our democracy. With this many people in the room and this many people online, we know that in Wisconsin we've got energy and commitment. Let's continue our conversations. We have a reception outside. Ask questions of the speakers, talk to each other. Did I mention that we have a sign-up form? If you haven't finished your sign-up form, no cookies for you. Thank you very much, and I look forward to our continued conversation.